pin me down.
We're on the record.
Okay, great.
So we want to be
Okay, we'll
careful.
call this meeting to order at 4:05. Exactly. Okay, let's call the roll.
This is the meeting of the Sunshine Ordinance Task Force for February 1st, 2017. On the call of the roll, Member Barnetsky. Barnetsky present. Member Eldon. Eldon, just to make the statement, the following members have informed us that they were unable to attend today's meeting and will be marked as excused. Member Eldon, Member Josh Wolf, and Member Moss. Member Eldon, excused. Member Josh Wolf, excused. Member Copra absent. Member Tesfa.
Present.
Tesfa present. Member Moss, excused. Member Kanata.
Here.
Kanata present. Member Fisher.
Here.
Fisher present. Member Hinsey.
She'll be late.
Hinsey has informed us that she'll be arriving late today, but she will be here later in the meeting. Vice Chair Hyland.
Present.
Hyland present. Chair Wolf.
Here.
Wolf present. We have a quorum.
Very good, thank you. Okay, so any changes, adjustments to the agenda at all? Okay, seeing none. Let's get a motion so we can get public comment going to approve the agenda. No, agenda. Well, there are no changes to the agenda. Okay, so we don't need that. Let's carry on. Okay, so call the next item.
Item number 2, approval of minutes from the Sunshine Orange Task Force January 4th, 2017 meeting.
Okay. Any changes to the minutes? No changes. Have a motion
Move to approve.
by Member Kanata.
Second.
Second by Vice Chair Hyland. Now public comment on the minutes.
Good evening, members. Peter Warfield, Executive Director of Library Users Association. It's disappointing that we only have 6 members to start with here, and looks like we're only going to get one more. So with respect to the minutes, I marked my copy. So on page 2 of your minutes on item 3, which is the complaint of Library Users Association against City Librarian Luis Herrera. Appreciate that we succeeded in that complaint, but where there's a summary of what I said, Mr. Warfield stated that the records provided were incomplete and that the referenced website provided was not easily navigated. Now, that may have come up as a secondary matter, but my primary concern was they have to provide the documents that they have or have access to and not answer by sending somebody off to search a website. In other words, a key claim there was that while it's fine if you want to give extra information, say there's more information over there, but that doesn't substitute for the library providing the information that it has and had. So the key there was that he should not have been required to get information on his own from a website controlled by an outside entity rather than getting it from the library. That was key argument there. So I'd appreciate if you would add that small bit to round that out. With respect to item number 5 on public comment, speakers Peter Warfield, Library Users Association, stated that the task force should have the respondent attend the meetings instead of representative. So I think that that needs to be clarified. I what I said was that the people who were directly involved in creating the violation or the alleged violation should personally be asked to be there rather than secondhand what in court might be called hearsay. Thank you.
Any other public comment on the minutes? Seeing none. Are we okay with making those adjustments in the minutes? Yeah?
Motion to edit.
Okay.
as stated.
Did you gather the,
I will review the audio and attempt to insert that additional summary.
okay, great. And so the essence, I believe, what Mr. Warfield is expressing is that in his, in paraphrasing what he had stated, that he should not have been directed to an external website, but the library should have provided the information directly to him.
So I'll make a motion to adopt as amended.
And on the second item, that the people directly involved should have been present.
Yes.
Okay, you got that part. Okay, good. Okay. Okay.
Does the mover accept that?
You move.
Accept.
Member Kanata, do you accept the edit?
Yes.
Okay, great. Okay, no other public comment? Okay, let's take a vote.
On that motion, Barnetsky.
Aye.
Barnetsky, aye. Eldon excuse. Josh Wolf excuse. Copra absent. Member Tesfa.
Aye.
Tesfa, aye. Moss excuse. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Hinsey, absent. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, great. Okay, call the next item, please.
Next on the agenda is item number 3, file number 16093, review and possible amendments to the Sunshine Ordinance Task Force bylaws and complaint procedures. I believe at the last meeting, we left off with mid-discussion with discussion of the minimum requirements to process complaint and absence policy.
Great. We're taking these up at the beginning of the meeting because our meeting got cut off last month by a unplanned or planned alarm test that was so loud we couldn't hear ourselves think. So we're picking up some of these items that we were unable to get to at the last meeting. Okay, so Member Baranetsky, since you provided some suggestions for this, why don't we start with that and then we can continue with our discussion.
Sure. This was a draft that was based on the complaint rules that existed. So this is sort of a scant revamp of that. So basically, this is supposed to propose dividing the instructions into 4 separate sections, hopefully in an order that makes sense. Basically, how to submit a complaint, what to include in it, requirements for the case, so AKA whether the complaint would be worthy, and then just a general note on public openness and anonymity. In particular, I focused on the second section, which discussed what to include in the complaint. And these were based looking at different rules, including in California courts, state courts, as well as the federal rules of civil procedure. So to make it basics, an understanding that in the complaint you should just explain what the facts are, right? Just so there's a general understanding in the facts, including what agency is to be named, the department where the request was submitted, description of what's the violation, so what are we specifically looking at in the ordinance, including any documentation, and then lastly, just how to contact the requester. This was all included in order to make it easier for and more clear and efficient in processing complaints and making sure that they were thoroughly accepted from the get-go, not having to have any sort of remedial actions taken subsequently to refine the request, to refine the complaint. So these are some proposals. What I'd like to say is, there are different sections that basically this is not final language. This was still supposed to go under additional review with additional feedback. So there may be typos or, the X's, for example, are just supposed to be places where there's supposed to be fillers. But this is the general proposal.
Any comments? I have one. I think it's important that complaints be filed, like let's call them petitions, are filed for in a timely manner. So we have experienced over time, at least in our term here since last June, that many of the complaints that have been filed were on violations that happened so many months or even sometimes a year prior. Okay, I'm not talking about continued items, but I'm just talking at the brand new complaints being filed, requests for hearing being filed for complaints that might be very, very old, a long time ago. And I don't think it's fair to the parties, but also I don't think it's fair to new members of the task force who were not party to possible incidents at that time, whether they were hearings prior or whatnot. We want to try to keep everything as up to date as possible. And also the problem with that is there's turnover in staffing. And so if something happened 6 months prior and since then somebody had left the position, that person left the position, then what? Should a hearing continue because the person's no longer in the office? They may not even work for the city anymore. So having the actual time, the period when the violation actually happened, when the request was violated, and the time that the petition or the complaint has been filed with our office needs to be shortened. And so I don't know what that should be, days, weeks, months, but I open for suggestions on that part. So I want to throw that out there as something to add to this particular procedure. Oh, yes. Member testify.
Yeah, I wanted to echo that. I think something between 3 to 6 months at the most would be appropriate. And I think it's something that we should try and encompass in all of our work in order for all committees to be able to move things along. And I think a similar idea should pertain to complaints when, if a respondent isn't available one time, that's one thing, or a petitioner, but, allowing them to reschedule. But I think that we really need to get things on the agenda as soon as possible so that we can keep all of the cases moving along. And I know that sometimes people can't be present for whatever reason, but we need to try and limit it as much as possible to allow this organization to meet its statutory requirements, while giving some flexibility to petitioners and respondents. But we want to make sure that we're able to meet our statutory obligations. So.
Okay, great. So this is just to reiterate, this is the procedure for a member of the public to file a complaint. So are there any 3 to 6 months, you would think? Okay, Member Baranitsky.
Just understand it's 3 to 6 months from the time of when?
From the time that the requester considers the request being violated. So you start in January, you do the 14 days, you didn't get the documents you asked for after 14 days, you make another request or follow up on it that may take another week or so. Finally, at the end of January, you decide you're not going to get the documents requested, so file the complaint with our office, file the, for violation within what period of time from that point?
We're saying 3 to 6 months from now.
3 to 6 months. So my question then is should it be longer, shorter, or whatever? I mean, I would much rather have it be shorter so that it gets into the hopper faster. It's timely, and whoever the alleged person who was in violation could still be around and make it. At least it's in our system quickly and it's timely.
I would like to amend what I had suggested to being 3 months. And of course, I would like to hear the public comment on it, but especially people who have had experience putting in petitions. But I find it frustrating when we have respondents that come before us who not only are new to an agency or a department, have completely cleaned up the act of the department, and then they're made to answer for someone else's misdeeds. I just don't think it's fair. And, I don't think it's really helpful to the process, to the original person needing those documents 3 months ago.
Yeah,
Member Canado.
and I'm not sure on the time frame either, but just from my experience, running a neighborhood group, going to the planning commission a lot, the city body, the city employees are there to do the job, where the citizen, whether it's going to a meeting or requesting information, the citizen usually has a full-time job or it has other things going. So I wouldn't want to make it too short of a period where the person putting in the complaint feels like, oh, I have to do this tomorrow. Or if they forget about it for a week, they run out of time. So I think, we need that. I think that needs to be discussed. And I agree that public comment would be helpful on that.
Okay. Okay. Any other items? Yeah, we will in a moment when I call it. All right. So let's. Usually, I'd like to get something on the floor. So that way the public comment applies to what we're about to pass. So let's do that, and then we can decide whether we need to continue it or not. So I need a motion.
I'd like to make a motion that a petition needs to be filed under the Sunshine Ordinance within 3 months of the initial request for public records.
3 months from?
The date of the initial request for public records.
Oh, okay.
I would love to hear public comment on that, but that's going to be the initial motion.
Okay.
And do we need to put in the motion the initial request for records or the meeting in question?
Oh, sure.
If it's
Sure.
If it's an open meeting violation, okay.
Okay. All right. Is there a second? No second. Okay. So our complaint procedure will stay as it is? Okay.
I'd like to make a motion that it be, I think, 5 months, something like that, or 6 months. I don't know. I think could we discuss this a little bit?
I'll
Well,
second
that's
it.
what
I would
I'm
like to
saying
hear
is
public
if
comment,
you
so
just-
I will second that.
My hesitation is, I know for like a FOIA suit, for example, you have up to like 6 years to file something like that.
Yep.
Right. That's way longer than we want to be
Right.
offering. However, 3 months also seems that's something that an attorney would have in mind when they're keeping this open, when they're thinking about timelines, that 3 months is a reasonable amount of time for an attorney. But I'm thinking that maybe a member of the public who has other things on their mind that's not doing this 9 to 5, we would want to, either double it or at least give a third more of the time. So maybe like.
Okay, so let's get a motion on the floor to amend the complaint procedure, and then we can,
And then
we can have
discuss.
more
Yeah,
discussion and
wait
get
for
some
the
public comment on
Sorry.
this.
So then I would propose to amend the complaint procedure so that it incorporates 6 months as the time period for the last time that a complaint could be filed, since 6 months from the time of the denial
From the denial.
or lack of access.
Well, there might not ever be a denial if there's no response.
Let's get it on the floor, and then we can discuss it. We could either vote it up, vote it down, and amend it again, so we can get some public comment on this.
I'd like to amend that motion to be from the initial date of the request, only because.
Wait a second. Nobody seconded the motion, so if nobody seconded the motion, then it's dead again, okay?
I'll second it.
Okay, great. All right, so now.
Now I'd like to amend it to be from the date that the petition, or that the record request or public meeting request was made, only because I feel like in many of the cases that we hear, it's inaction. The person doesn't receive a response at all. So I would hate for the clock to start when the person receives a denial, because they may never receive a denial.
Agreed.
Okay, is there a second to that
Second.
amendment? Okay, so moved by Member Tesfaye, seconded by Member Kanata.
Through the chair, I'm a little confused.
Yeah.
I thought she was, as the second to Member Baranetsky's motion, adding that as a friendly amendment.
No,
That's the second,
this is an amendment to the original motion.
which already died. on the
No, it
floor.
didn't die.
Or never got seconded.
No, so what happened is Member Baranetsky moved that it should be 5 months from the point of the instance of the violation. Member Tesfaye seconded it, so that actually made it active. Member Tesfaye then immediately moved an amendment.
Okay.
Okay, it's basically a replacement.
All right, so we have one
for the
motion that we're considering.
We have, right now, we're moving to more or less replace the language of the original motion. Okay, so let's get some public comment.
Peter Warfield, Executive Director of Library Users Association. I do want to ask, are we also talking about the additional materials that were discussed up here, or just the motion about, because I'd like to comment on an item there.
That's not part of this motion.
Okay.
We may make more motions.
Okay. Well, I certainly disagree with a very particular point up here, but with respect to this motion, it's absolutely dismaying to hear this from this body, which is supposed to be, as it were, user-friendly for the public. There are many reasons why somebody might not file a complaint right away. Let me say that in respect to the direction things have been taken, you will later hear one of our complaints that we filed within 4 days of a violation taking place. However, there are many times, for example, when somebody may not want to or be able to or know that a violation has occurred. Let's take the example of something that passed. I request information. I get a partial response, not knowing that it's partial. How do you know how long it took me to find out that they were cheating me? It might be a month, it might be many months. Somebody might drop something in conversation that says to me, gee, I didn't know about that. I better check up on that as best I can. And then eventually, however long afterwards, it may be the case that I discover there's been a problem, that I didn't get the full answer a year ago or even 2 years ago. There is no statutory limit in the law. So I think you also have a legal problem to accept every complaint that comes and to deal with it in good faith and not put ropes around people that will chuck them out of the process. You also haven't specified who determines whether something has been meeting the qualifications or not, and in a prior round, you have the administrator decide whether some of these things were satisfied, and I think that's highly inappropriate. So you also need to decide at what point in the process, you make the decision, because you are the ones who are supposed to be dealing with complaints. There's a lot more to be said about this, but the reasons are many why somebody might consciously not want to file. For example, if there's a series of information requests and they don't want to get bogged down in legalisms but hope to get some information, that might be another reason why they might want to hold off. So I think that this is a very bad idea. Thank you.
Any other public comment?
I did not expect to be speaking to this issue tonight. I didn't know it was going to come up. But I have a lot of concerns about this motion because I'm here tonight. My name is Mike Black. I'm here tonight because of a request I made exactly 1 year ago today against, I made the request to Animal Care and Control, and my complaint is against Animal Care and Control. And, certainly part of it's my naivete, my inexperience, but I would never have guessed there was a time limit. And with my request, I didn't even get an answer, a response of any kind to my request for 30 days, for a month. And then I got a very incomplete response. I let them know I thought it was incomplete. 3 weeks went by. I didn't get any response at all until I emailed them again. And this went on month after month after month until I filed this complaint November 7th, 10 months later. And I just don't know how you would expect some citizen like me to know, no, you can only give them 5 months. You can only give the agency 3 months or 4 months or 6 months, and then you have to go to the Sunshine Ordinance task force. And if you're going to do that, if you're going to make that information really readily available to people, it might work. But in my case, I felt like I was being the nice guy trying to give them chance after chance after chance after chance to fulfill a request. And here we are 1 year later. And I don't think I should be penalized unless you're going to make it really well-established law in the city that everyone's familiar with, that you have 6 months to complain about someone not giving you a public record. Thank you. I second this gentleman's comments completely.
Thank you. Any other public comment?
Good evening, David Pilpel, former task force member. I rise to speak in opposition to this, 3-month limit on filing complaints. There's nothing in the law that allows this task force to set a limit on filing complaints. I don't think it's a reasonable limit. I think there are a number of circumstances under which someone might only determine past a 3-month period that a records request was incompletely responded to, or that a meeting violation occurred and would bring that before this body. I think you could certainly include language that complainants are encouraged or strongly encouraged to file complaints within 90 days, but I think to prohibit a complaint from being filed past 90 days is beyond your scope. There certainly would be more difficulty for a complainant to establish the facts if it's as time passes, and it would be more difficult for respondents to adequately explain the circumstances if staff members have gone or whatnot. But we've seen that many times at the task force, and it's been dealt with in an appropriate fashion. So I oppose this particular change and recommend that instead you consider the language encourage or strongly encourage, but not to set this kind of limit. If the law changes, then this could be re-examined, but given the current state of the Sunshine Ordinance, I think it's beyond your scope. Thanks.
Thank you. Any other public comment? Okay, back with us. Yes.
For those of us who walked in late, can we repeat the motion?
So the motion is to require that complaints be filed with our office within
6 months.
6 months from the from the point of that the request was made by the requester.
Okay.
And this would be an amendment to our current complaint procedure. And this is an amendment to an original motion, which was for 5 months. It's replacement. It's a replacement motion, basically. For would be that the complaint would be filed 5 months from the point the requester determines that a violation has been made.
Got it.
Okay, thank you. All right, task force members, comments? Member Canada.
I mean, I think the public comments raised a key issue, because the knowledge of the average citizen on what they're allowed to get may not be adequate enough to limit it to a time limit.
Okay. Vice Chair Howland.
Through the chair. Yeah, I think the public brings up a good comment as to whether this is in our purview or our scope. I tend to agree. I don't think it is. I'm just curious, though, in practice, perhaps the chair could talk about in the past, was this ever discussed, considered, moved? Is there any precedence for discussing a statute of limitations?
Not that I'm aware of, at least in this iteration, since we've had discussions about making changes to our procedures. My concern was when we first started, we were hearing all kinds of complaints that occurred well over a year prior, and made it a little difficult for us to understand how, what happened during that time. The other big factor is that what if the respondents no longer work for the city? Then how do you dispose of a complaint, which is not codified in the ordinance? And I'm not sure what the precedent is on maybe ethics violations or other human resource personnel type violations, contract violations, that kind of thing. And because we don't manage any kind of penalties or enforcement, so all we can do is come up with a determination.
Yeah. And to complete that thought, as long as I've been on the task force, we have had a backlog. We have dealt with older cases. And in many of those cases, it's been that the person who was the initial records keeper or I guess, records person is not even around anymore. But I think these, these changes should deal with what happens once a complaint reaches us and how we adjust that. I think trying to control how and when a complaint can get to us in the first place is outside of our scope, I think. So I don't think the law allows for any statute limitations. I don't think there's anything that will, we can adopt this as much as we want to, maybe even get it passed, but I think ultimately the law won't allow it, is my feeling so far. To balance that, we've also had times in the past where we've heard cases that go back 2, 3, 4, 5 years, aka fishing expeditions that really, maybe shouldn't be allowed to proceed. And that's another discussion. But I don't think this particular motion is going to address that either.
I guess one of the things that comes up for me about this, and I think it's important to say that how many members of the public even know that there's a sunshine ordinance. I think that that's an important factor because somebody can make a request and then it doesn't come. They don't really know that there's a law that actually controls how public information. They may have heard of a Freedom of Information Act request, but they may not know that, what the particulars are around it, and you have to go research it. But there are, people that do know that there is a sunshine ordinance and state law around this that the ordinance is inclusive of, and that there's a limit on the return of requests, which is either 10 or 14 days, depending. So let's say it's a maximum of 14 days. I mean, how long is a person going to wait until they file a complaint? That becomes question at this point. I think that was some of the motivation for bringing this particular item forward. So how should we dispense with this? Any other? Yeah, Vice Chair Hyland.
I think perhaps we take a vote so it's on the record and show that, for future task force, if this comes up again, we've addressed it and here's determinations and here's where we went.
So did this motion it did get seconded, right?
Yes, it did.
And could it be repeated again, just one more time? This was the 6 month, right?
Yes, the motion is to place a 6 month limit from the time of the initial request for public records as the deadline for filing a complaint.
And open meetings. And open meetings.
And open meetings.
Okay.
Okay, so let's call the roll.
On that motion, Member Baranetsky.
Aye.
Baranetsky, aye. Eldon excused. Josh Wolf excused. Corporate absent. Member Tesfa.
No.
Tesfa, no. Member Moss. Moss excused. Member Kanata.
No.
Kanata, no. Member Fisher.
No.
Fisher, no. Member Hinsey.
No. No.
Hinsey, no. Vice Chair Hyland.
No.
Hyland, no. Chair Wolf.
No.
Wolf, no.
Sorry, can I change my vote? to
Yes, you
no?
can.
I said aye incorrectly.
Baranetsky, no.
No.
The motion fails.
Okay, motion fails. Are there any other amendments to the complaint procedure? Okay, let's move on to the absence rule, I guess we call it. We left off some discussion as to whether, in dealing with excused absences, whether we should leave it at the discretion of the chair or have it be some other way to deal with excused absences to try and curb absences. What page?
There is no specific page.
There's no specific page as part of the list.
Item number 3.
And the absent, it's on page 18 of the attachment. Just says absent policy, adding an excused provision. And we've had some. This is a continued item. We've had some extensive discussion on this. I think it was in November. October, November.
Yeah.
Vice Chair Hyland.
Through the chair, if memory serves, we thought this would be a cut and dry, black and white type of issue, and it really isn't, as evidenced by the previous discussion. So I think two things. We kind of already are using a excused absence procedure as evidenced by tonight. But I think ultimately, given 11 people's schedules and meeting room availability and everything else that's going on, I think it's wise just to leave this to the discretion of the chair. So that would be my.
Okay. Member Canada?
Yeah. My feelings on it when we were talking excused absences is that's a very subjective item. What's excusable?
Yeah.
And to the issue of everybody's schedule, everybody here signed up to be on the task force knowing that there's one meeting a month, not counting committee meetings, subcommittee meetings. So I would say that there should be a fixed number of absences, and after that, whatever should occur occurs. You know, whatever reporting is done or anything. But to me, to have an excused absence puts the onus totally on the chair. And again, what's excusable?
Member Hinsey?
I think that when we discussed this at the Rules Committee, we were thinking of if someone notifies the chair, then that just counts as an excused absence. The only time when it would be an absence would be if you no call and no show. But then that gets into this idea of like how many excused absences do we allow, and what sort of weight does that give an excused absence versus an unexcused absence? I would say that if we're gonna adopt a policy, just to let the chair know, and that counts as an excused absence. I'm not familiar with the formalities of reporting to the Board of Supervisors and all of that.
Okay. So our current policy is just 2 absences, and then it gets I think a warning from me, and then it goes to the Board of Supervisors, right?
Yes, in 2 absences in the 12-month period.
Right, 2 absences, 12-month
Through the
period.
chair, I'd be curious to hear, and maybe there are people in this room that were around long enough to when the charter was first put together, as to why that language was put in the first place. I mean, I think the reason behind it is that because, you know, it was a charter by the people, but elected by the Board of Supervisors, they wanted real people, bona fide people that would actually be here and serve and show up for meetings. And maybe that's why the language was put in there as a safeguard.
It's not in the ordinance. It's an internal
I see.
policy of that the task force self-imposed on itself.
And when did
In the
that
bylaws.
It's in the bylaws.
Is it a bylaw? That was my question.
Member Canada.
But it's also, to me, it seems it's very important to the Board of Supervisors, because in last May at the Rules Committee, when all of us who were elected in May, everyone who went up there was asked the question about attendance, because they had a lot of non-attendees. So to me, it seems very important to the Board of Supervisors and to this body. And I mean, I don't know if 2 is the right number, but I would think there should be a number, and that would, and then that would be it.
2 per calendar year, I believe. I believe it's 2 per calendar year.
Yeah, calendar year.
Yeah.
Member Hinsey.
Well, if it's more than 2, then if we think about it, we only have 12 meetings a month, or 12 meetings a year. So if you miss 3 of them, that's a quarter of the meetings. Is that?
Yeah.
That's a lot of the meetings.
And then 3-4 years ago, we had 24 meetings a year because we were doubling up. And then that whole thing changed.
This doesn't count committee meetings.
Or special meetings.
So-
Yeah, not even talking about committee meetings. There's special.
We had 2
full task
sunshines,
force.
yeah, every month.
So I've reviewed this with some other associations and organizations, that kind of thing. They tend to raise the bar, and basically force the actual body itself to award an excused absence. And so it becomes more peer pressure among your colleagues to determine that. Because you're already, the leniency or not, the limit is 2 per year. If you wanted to, try to get one not to count, then you'd have to convince your peers to give you the excused absence. That's kind of the high bar that a lot of deliberating bodies use. So I'm just throwing that out. I'm not suggesting that. I'm happy to leave things as they are. Usually, I'll tend to give an excused absence for, really good reasons. Somebody, their boss called them into work and they got to go, kind of thing. So something very unexpected, kind of thing. And if they do it within enough time, like not the night before, unless it's an absolute emergency, kind of thing. But I'm not,
I feel like when your boss is calling you in or whatever, it's usually like a last minute thing. So I don't know.
Sometimes it could be a scheduled kind of thing, but usually it would be like within 3 days, 5 days, kind of like within the week, I would say. Like you had to have a special kind of meeting that demanded people to travel or something. But I mean, it's that kind of thing. There has to be some level of urgency attached to it that is unforeseeable, and that's kind of the bar that I hold. I mean, Member Hinsey.
Clearly, like one of our members has surgery, that's, unavoidable. He just happens to schedule it on first Wednesday, that's completely legitimate. So I see that. I see you being able to set the bar as a reasonable chair, as a reasonable prerogative, so to speak.
Okay, well, it sounds like that we want to kind of leave things as it is.
I mean, personally, I would.
Go ahead.
I would rather leave it at the 2, and if you miss more than 2, then you're kicked off. As much as I don't want to be kicked off, I think that if you can't make that many meetings, maybe you're just too busy to be doing this. But it's hard because we have this main meeting and we also have our committee meetings, and you might be making all of your committee meetings and you're not making this main meeting, and that's tough. But and I don't want to be kicked off myself, but I don't know. It's like you have to have a hard line somewhere, and then people can hold themselves to something.
I thought you were just going to announce that you're going to be missing the next meeting.
I might be, but I mean, you get 2 absences. So.
Okay. Okay, we don't have a motion on the floor, but I'll open it up for public comment on this item.
Peter Warfield, Executive Director of Library Users Association. You have procedures under Article 2, Membership and Attendance, Section 2, Attendance. The overriding issue here, I believe, is accountability and the great importance of regular attendance. Member Kanata, I think, has put it well, and so has Member Tesfaye. It's quite plain here. You are notifying the administrator, it says, notifies any member who misses 2 regular meetings, not in a calendar year, in any 12-month period. So that's a rolling period. If a third or subsequent absence from a regular meeting occurs, the chair of the task force shall notify the Board of Supervisors of the member's lack of attendance. So you don't actually provide for getting kicked off here. That seems to be in the hands of the Board of Supervisors. I would certainly approve at least some recommendation of getting kicked off, as you say, to be tough, because it's very, very disadvantageous to the public for even one person not to be present. You have 11 members. 1 seat is unfilled or 2. That's happened. All of a sudden, there's a supermajority required. A member gets sick, that happens, or is out of town on vacation. There's 3 members, 4 members, and quite frequently you have had a bare minimum quorum of 6 or maybe 7 or maybe 8. But in a democracy, a 6-2 vote is an overwhelming majority that is almost impossible in electoral politics ever to get. So I think you need to be very strong on attendance. That's crucial. We could go into more history about this and why Alan Grossman's proposal to change how votes are taken ultimately was approved by this body so that the respondent had to get a majority, and how that led to the big purge, the Scott Wiener purge. And then the next thing that the new task force did was buckle under and change the rule. And I remember from somebody who's no longer here swearing up and down that everybody was going to attend and there would be perfect attendance at all times. This meeting started with 6 and now has 7. There's a supermajority that's totally unfair to the public and yourselves in order to do an action. I think your rule is okay as it is. If you want to strengthen it, I would certainly think that's great. I'd like to know, has Rishi Chopra's attendance been reported to the Board of Supervisors? Thank you.
Any other public comment?
David Pilpel again. Just wanted to add further comment in reference to the actual law. Section 67.30E states, although awkwardly, the Task Force Commission shall approve bylaws specifying a general schedule for meetings, requirements for attendance by task force members, and procedures and criteria for removing members for non-attendance. In my experience, the task force has not included procedures and criteria for removing members for non-attendance over the 23 almost years that the task force has existed, kind of in violation of that particular provision, but instead has provided that, as you've heard and discussed, that upon 2 absences, the member is notified, and upon the 3rd absence, the chair is directed to notify the Board of Supervisors. Under existing precedent, the Board of Supervisors is the only body that can remove an appointed member from a body. And to my knowledge, that has not occurred. Members have certainly been appointed, reappointed, or not reappointed. But no one on this body that I know of has ever been removed by the Board of Supervisors prior to the expiration of their term. So the task force certainly could, under that particular provision, 67.30E, provide for those procedures and criteria for removing members. I would, however, advise that if you declare a vacancy in a position, then it simply has to go back to the Board of Supervisors to fill that vacancy, which usually takes at least 2 or 3 months. So I think the better solution overall is to just encourage members to attend and to simply report to the Board of Supervisors or threaten to do so when a member doesn't attend. The whole point is to get people to attend. It's not really to be punitive. We kind of want people to be here. Anyway, I also think that if the task force is going to propose to amend the bylaws to deal with this issue, the specific language should be before us. And I didn't see any specific language, just a category on page 2 of items outstanding. Thank you very much.
Any other public comment? Okay, seeing none. So it's, I think it just sounds like we should just leave it as it is. We'll have more discussion if issues come up. And we'll have the Rules Committee help bring some language forward if we need. All right. Well, we'll stop there with these list of items. I will take suggestions from you all as to the rest of the list, as to what we should discuss on for next month's meeting. And that's it. Okay. All right, so let's move on to the next item. No action.
Next on the agenda is item number 4, Sunshine Ordinance Task Force Chair's Report.
Okay, so I had asked our legal counsel to check into this item. I had noticed that there was an addition or an edit to the online version of the Sunshine Ordinance, and looking at what was submitted originally, which is also contained on the same website, and to what was in the voter pamphlet in 1999, did not see Section 67.3B4 capital C-1 included anywhere. And now it's in there, and there's a notation that the drafters of Prop G inadvertently omitted this section. Now, I've spoken to a number of the framers of the ordinance, and they have no recollection of this being there. So, DCA Cola, did you come up with any answers for us?
So this was just inadvertently omitted by the drafters of Prop G, which was on the November ballot in 1999. But the Sunshine Ordinance, a version of it, had already been in existence since 1993, and that was passed by the Board of Supervisors, and that included this. So after the omitted version, the version that omitted this provision was passed by the voters in '99, they realized that they forgot to add this section. Some lawyers on the government team in my office at the time did a legal analysis and determined that just because there was already an existing law that included this, the voter passed version in 1999, Prop G, because it did not include this, doesn't mean that it just got rid of the law that had already been passed. So there were edits that were clearly included in the proposal that was Prop G that was passed that were additions or deletions from the original 1993 Sunshine Ordinance. But because this was omitted, it was ruled to not have been affirmatively deleted, and it carried over as existing law from the previously board enacted Sunshine Ordinance.
When did somebody realize that this happened?
Shortly after it was passed, sometime in 2000.
But this hasn't been there. This wasn't there in 2000.
I believe it was.
Not online. Not since I've been on the task force prior to here. In all the years that I've been on the task force from 2005 to 2012, I've never seen this clause in there ever. So it had to have been included sometime between 2012 and this year, or last year.
I spoke personally to the attorney who actually handled this, and he told me that it happened shortly after the November election, that they added it in sometime in 2000 or 2001. So maybe the version of the Sunshine Ordinance that you had access to had been outdated, or maybe the website that the city contracts through to provide an online version had omitted it for some time. But
where does then somebody find the official version then? I mean, which one is the official version that people are supposed to follow at that point?
The one that you have access to now that's online.
Right, and that's what I'm saying is that this particular clause was not there prior to 2012.
They weren't the best word.
I've been informed otherwise.
Okay, all right. Okay. All right, I just find it a little problematic. I'm sorry, who? Oh, member
I just think
Tesfaye.
that this reads really awkwardly. Are they saying something is not allowed? grammatically, it doesn't really make
So,
sense to me.
well, the version that's included in this agenda item is just that actual subsection, but above that subsection, it says, these are the following circumstances that do not, that will not be considered or will not be, that won't be considered a meeting. So in this instance, it's when multiple members of a policy body are in attendance at a different policy body meeting just as individuals. That's what they're saying here.
Or of its own standing committees. So for instance, we're not a policy body, but if during a committee meeting, like more than a quorum of members show up, okay, those members could only be observers. Those additional members could only be, they couldn't participate.
In order for it to remain as...
It's a restriction. It's a restriction. It says that those members can only be only the members who are only the people who are not members of the standing committee. They can only attend as observers. They can't participate.
And if they do participate, then what happens? Then
Well, it's a violation.
No, then the meeting becomes a different type of meeting, right? It's not that it's a violation. It's just that it becomes a different type of meeting that's subject to other.
I think by implication it would be. It may, but the point is that it's a restriction. So I would say that if somebody were to take it to task, let's say some actions were made,
Yeah.
it could be taken to court can reverse it.
Okay.
I would think
And
something
is the
like
concern
that.
here that it would be a violation of the Open Meeting Act because it wasn't posted, noticed that more members would be attending, or what?
We're getting a little bit too, it's just too much into speculation
Right.
right now. This is all in 67.3, which is just definitions. So
Right.
this is defining what a meeting is. So the first part of the section defines what a meeting is, and in this small little portion that had been added into our agenda packet for the night is just part of a list that says what doesn't constitute a meeting. It doesn't speculate beyond that or what the repercussions of what it
Right.
what it are.
Yeah, it's not codifying anything specifically.
Right. I mean, I think what the repercussion would be, though, is if it's a certain type of meeting, then it will be subject to sunshine ordinance. That's why the definition is there. It's to let people know what kind of meetings they are able to have access to documents for, et cetera, or what types of meetings need to have certain types of agendas or certain types of notice. That's why I always thought those definitions were there.
Sure, it could potentially trigger violations of other things, but it would all depend on circumstances from that point.
It does seem a little misplaced, like maybe it shouldn't be a definition. It should be actually in the meat of the actual the ordinance itself, because it is kind of directive versus describing something per se. So that's why I was curious about this. The other thing, DC Acola, is when you go to the website that the city contracts for its codes, which is American Legal Publishing Corporation, under the very, very last section after the appendix is a reference to ordinances, and these are the ordinances that were included. I'm sorry, it's the table. I'm sorry, it is the appendix, the table of initiative ordinances. And that was the actual original one that was included at the time, and it's dated. And this particular section is not in there. So I understand what you're saying, that this was somehow inadvertently omitted during the election process or during the creation of the ballot pamphlet. But it's unclear to me because there's no reference anywhere to it. I don't see it existing, that language, anywhere. I can't find it. So that's what I'm kind of asking for, is a reference to where I can actually see it.
Sure. If you want to dig up the 1993 version of the Sunshine Ordinance that was enacted by, or that was passed by the Board of Supervisors, it was formally codified as 67.3B4, uppercase D, as in dog.
Okay. Thank you. All right, I'll leave it at that, and I'll continue with my research on it. I just found it to be kind of interesting. All right, so let's move on.
You want to take comment on that at all?
Sure, we can take some public comment. Why not?
David Pilpel, happy to provide the historical information you're looking for here. This section was included in the prior version of the Sunshine Ordinance as last amended in 1998. As you'll see in the legislative history, the original ordinance was 265-93. The last amendment was 129-98. This was inadvertently omitted from the text that was submitted to the voters. This editor's note has been in the legal code of the city ever since. This appeared as soon as the ordinance was codified following its passage by the voters in 1999. So this is not new language. Moreover, this language really just duplicates language that's in the Brown Act that already applies in 54952.2b6. So just as many other provisions of the Sunshine Ordinance parallel and duplicate provisions in either the Brown Act or the Public Records Act, so too does this provision. So whether you find it or don't find it, the provision and its language is operative in as much as the Brown Act is incorporated through Section 67.5. By the way, this is not the only drafting error that occurred in Prop G. Just as one other example, at the beginning of 67.25A, notwithstanding the 10-day period for response to a request permitted in Government Code Section 6256, et cetera, there is no Government Code Section 6256. It should have been a different code section. And there is, somewhat of a problem when you refer to a specific code section in another law and those laws are amended. So you can get into lots of questions about statutory construction and what was intended and what occurred, what existed at the time. Do you track to the language that existed at the time? Do you track to the language as amended, et cetera? I think perhaps you're looking for a problem that doesn't exist. This language wasn't before the voters to amend, and so the city attorney properly concluded that because it wasn't amended, that it stays. And so that's why the editor's note is there, unless you have any questions. Thank you.
Thank you. Any other public comment?
Peter Warfield, Executive Director of Library Users Association. To see a noun with a lot of variables and modifiers as an item for discussion is very puzzling. I don't think this agenda item is at all clear. It certainly wasn't clear to me what this was about. The full item reads, review of the validity of Administrative Code Section 67.3B4C1, quote, the attendance of a majority of the members of a policy body at an open and noticed meeting of a standing committee of that body, provided that the members of the policy body who are not members of the standing committee attend only as observers. There's no verb. There's no subject and verb. Thank you for nodding yes to member testify. So I looked at the original, and it's in the definitions section. I have no problem with wanting to discuss it and discuss it openly, and I appreciate that. But I think the agenda item needs to be clearly stated. In looking at section 67.3, it talks about definitions for this section, and it says definitions, and it says a meeting shall not be considered, the following shall not be a meeting. There's the verb, it's not a meeting. This is not a meeting, and that's why this is just basically a noun. A group of people attending from this body attending a meeting, as long as you only observe. And I think the purpose is quite clear and key to Sunshine, and that is, are a bunch of you going to go potentially, whether intentionally or not, to a meeting that in one way or another, let's say at the Ethics Commission or otherwise, discusses things that are relevant to your business here, and then basically come to an understanding about that issue. That then becomes an unlawful meeting that wasn't noticed. An unlawful meeting of a majority of the members of this body, or anybody that this applies to. So I think it's clear why that's there, and I think it's clear that it's core to the concept of sunshine. I think in this case, it's just saying a majority of you can assemble, let's say, at the induction of somebody or the swearing in of somebody, let's say. And there are other things that talk about a purely ceremonial event. So you can go there as long as you're not talking policy, as long as you're not talking decisions that might be forthcoming or cases and so on and so forth. I can only say that I think the purpose of this is pretty clear. It seems reasonable, and I'm not sure I understand what the issue is, certainly not from the way this agenda item was written. I hope in future there'll be clearer agenda items. Thanks.
Any other public comment? Okay, seeing none, just to be a little more clear about why I brought this up was because in my years, I had not seen this particular clause in there. And looking back from my research, I could not find a reference to it. I thank DCA COLA for bringing us the explanation for it. I am not contending its context or its meaning. That's not why I brought it up. I was just inquiring as to whether its placement in the ordinance at all was valid because of this notation, and not having seen it in any previous versions that I have used or have seen, and reading from the original voter pamphlet and from what's been included as reference to the public. So that's all. We can conclude with the matter at this point, and we need to go to general public comment.
Next on the agenda is item number 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
What, skip 5?
Yes, I did skip over 5.
Yeah, general public comments at 5 o'clock.
Oh, yeah.
Peter Warfield again, Executive Director of Library Users Association. Fairly briefly, I'm very disappointed not to see on the agenda your statutory requirement to render a decision to the public within 45 days of filing a complaint. That's in section 67.21, and if I have a copy of this section, I would like to see that. I would like to read it to you. For requests, for document requests, and by the way, I have to say again, as I've said before, the copy of the ordinance is not, this portion is not in your book that's present in this room. It is missing some pages, and key pages include the section 67.21 in full. So, section E for Edward, 67.21E. If the custodian of record refuses, fails to comply, or incompletely complies with the request described in B above, or if a petition is denied and not acted upon by the Supervisor of Public Records, the person making the request may petition the Sunshine Task Force for a determination whether the record requested is public. The Sunshine Task Force shall inform the petitioner as soon as possible and within 2 days after its next meeting, but in no case later than 45 days from when a petition in writing is received, of its determination whether the record requested or any part of the record requested is public. You are required by this law that created you to give a very prompt response, a determination to the person requesting documents. And it's extremely disappointing that I've raised this again and again over time, and I'm raising again tonight, and I don't see that on your agenda. Now, perhaps you're catching up, and I appreciate that, but the complaint that Library Users Association filed on October 28th is now more than 3 months or 90 days past the time that we filed. So we're talking about more than double what the law requires you to do, and I think it would be important for you to include this as a high priority. Justice delayed is justice denied. Thank you.
Point of information, why are you skipping item number 5?
Because public
Because public comment goes
comment.
by.
comment occurs at 5 o'clock.
The time,
Yeah.
okay, of course.
We're not the only ones.
Yeah, no problem.
David Pilpel again. 2 items related to item 12, but not on its substance. I continue to believe that holding a closed session on a complaint that's before the Ethics Commission is inappropriate. It, in my opinion, is not an adjudicatory proceeding before an administrative body to which the city is a party. I'm contemplating filing a complaint about it, but I just don't think that this body should be holding closed sessions about complaints that are held elsewhere. If a complaint is filed against the Library Commission or the MTA Board or the Board of Supervisors, you certainly would not want that body discussing a complaint that's before this task force in closed session at that body. So I don't see why you believe that you're properly holding a closed session on a matter that's before another city body, to which the city is not a party. The other comment I wanted to make, separate topic, I filed a complaint in late 2015 against the Commission on the Environment for failure to provide meeting notices to me. I withdrew that complaint last month with the understanding that things had been resolved and that I would continue to receive timely notices of everything that happens over at the Commission on the Environment. Last week, or 2 weeks ago now, the Commission Secretary failed to send me 2 agenda packets for their Operations Committee and their full commission, which included discussion of their budget proposal for next year. If you want to see me really unhappy, feel free to watch the SFG TV video of me making public comment at last week's Commission on the Environment. I was unhappy. I have asked the department head there to put a note to this individual's file. I believe that discipline is warranted. The explanation that I was given is that he simply forgot. Forgetting to do a core function of mailing notices to someone on the mailing list is a huge problem, whether you want to call it a personnel matter or violation of the Ordinance or the Brown Act, whatever you want to call it. It's a problem. It's a problem for me. It's a problem if it occurs to anybody. And I just wanted to call this to the task force's attention. I'm not sure that I'm going to file a follow-up complaint on that one, but I'm just wanted to caution again that people need to follow the law and need to provide timely notices for meetings. Thank you.
Thank you. Any other public comment?
I may have found another error in the code. 67.6. Oh dear. Maybe I can't explain this too well. If you go to 67 points, meetings of passive meeting bodies as specified in 67.6 paren D paren 4 is referred to in the ordinance, and it doesn't exist. There's no 67.4 I'm sorry, there's no 67.6D4, and it's referred to, I believe, in 67.6. Is that clear?
Yes, it's 67.6E. In the very first line, it makes reference to passive meeting bodies specified in 67.6D4.
Is that an error?
It might be. We'll review it.
Okay.
Thank you for notating.
Thank you.
Any other public comment? Okay, seeing none. Let's call the next item, and then after that, we'll take a break.
Next on the agenda, item number 5, file number 16092, complaint filed by Anonymous against Dr. Lydia Liang, Department of Public Health, for allegedly violating Administrative Code Section 67.25 by failing to respond to a media disclosure request in a timely and/or complete manner. On December 20th, 2016, the Complaint Committee, acting in its capacity to hear complaints, heard the matter and referred it to the task force.
Jurisdiction.
Motion to find jurisdiction. Did we recommend anything, Victor? I forget.
Yes.
You
Without-
recommended to find jurisdiction, but without a recommendation regarding the sunshine violation.
Okay, so moved by Member Hensy for jurisdiction. Is there a second? Seconded by Member Tesfaye. Any public comment on jurisdiction? Members, any? Yes?
He's not a member of the public. You're the he's the petitioner. He's anonymous.
Oh, okay, great. Okay,
You're next.
seeing none, can we move this by acclamation without objection? Seeing no objection. Oh, I'm sorry. No, I already asked for public comment. Okay, the item passes. All right, the petitioner, the complainant, 5 minutes.
So this is a complaint against the Family Health Center, Lydia Leong, the director, where I have been a patient for more than 25 years and participated in their Family Health Center Patient Advisory Committee in past years, and also, I'm not sure if you're familiar with this kind of committee, but they exist in many health clinics and centers in San Francisco. And I also participated in patient advisory committees at the Potrero Hill Dental Clinic and also at San Francisco General Hospital in past years. I requested all documents and communications for the period January 1, 2014, up to and including September 18, 2016. What they sent me was a brochure, an advertising brochure, that, with one exception, is undated. And the only exception in the brochure is a sample agenda in that time period. In my experience of many years participating in these committees meet many times a year, and in fact, on March 24th, 2015, I briefly attended the meeting of this body at Family Health Center. It happened at Building 80, 5th floor, room 505, and I went there because I was petitioning to save the 33 bus line. What's missing, I believe they're in violation of the Sunshine Ordinance because they failed to provide me with any agendas for that period, including the one where I personally went to the meeting, so I know there was a meeting. They have not sent me an agenda for the meeting that I attended. When I went to the meeting, I didn't ask for an agenda, only it occurred to me later that I would need one. But also, there are I've received no personal communications, no dated communications for that period during the year and a half of my request. I think they're in violation of sunshine on that basis alone. The ordinance requires, if you look at section 6.7.4, passive meetings. The advisory committees are considered passive meeting bodies, and the section 6.7.4a, all gatherings of passive meeting bodies shall be accessible to individuals upon inquiry and to the extent possible consistent with the facilities in which they occur. Such gatherings need not be formally noticed except on the city's website whenever possible, although the time, place, and nature of the gathering shall be disclosed upon inquiry by a member of the public, and any agenda actually prepared for the gathering shall be accessible to such inquirers as a public record. So it's in violation of that section that I think you should hold them accountable. I can't believe there hasn't been any communications between any members of that of the body. I personally had contacted Lucia Angel to attend that meeting in 2015, which is within the time frame of my immediate disclosure request. They didn't send me any documents that indicated any communications with her or the director of the Family Health Center at that time, who was a different person, by the way. The body, I don't know if any of you had a chance to look at the brochure, but the brochure is full of legalese and is restricting the public's access to these bodies in direct contravention of the whole purpose of these bodies. The purpose of these bodies is for the patients to openly communicate with staff about the operations there, the level of service they're receiving, and to have an honest exchange. There are numerous restrictions that are in the brochures, which unfortunately I believe this is consistent with the effective shutting down of these advisory bodies.
Okay, your time is up. Thank you.
You're welcome.
Are there any witnesses or persons to provide any facts or evidence on behalf of the complainant? Seeing none, the respondent, you have 5 minutes. Yes.
Hi, good evening. My name is Lucia Angel, and I am the patient experience lead for the primary care San Francisco Health Network. So a little bit about our Patient Advisory Council initiative. So I, as actually a member of the Family Health Center, or a staff person at the Family Health Center, started a Patient Advisory Council. It was a volunteer initiative where we invited patients to volunteer to improve the quality or participate in quality improvement for patient experience and patient satisfaction at the Family Health Center. At the time when we received the request for information about this committee, I was actually had transitioned to a post in the central team, where I was charged with actually starting advisory councils like these in various clinics. Those clinics have actually only had councils in existence for the last approximately about a year, and their sole purpose have been to develop a process for patients and family members or people who have had experience in the system to become volunteers and improve the quality of service. If the information that we submitted was the process by which we usually identify volunteers at San Francisco, or the San Francisco General campus clinics. They actually go through the volunteer process of the hospital. So they get interviewed, they go through orientation, they receive a badge, and they participate in these monthly meetings. as part of identifying the improvement work or improvement projects that they will be participating as volunteers in, whether it be doing navigation for other patients in the clinic, helping create different boards or signage or whatever is identified by that group. And they do sometimes attend some of the staff meetings to talk about the improvements that they've been working on. Is that it? I don't know what else. But for the most part, most of the work that we've been doing has been through the process of, or through the context of a volunteer program. I also actually coordinate the volunteer initiatives in the community-based clinics for other things like health coaching, where it's usually mostly pre-med or pre-health students or other people interested that we facilitate their participation in other improvement projects that are supporting their future in healthcare, but also helping with the improvement of the clinic. So that's kind of the context where this program initiated. These bodies are different than maybe what I imagine others have participated in the past, which are community advisory boards, which are community-based groups that help inform policy or other things. This group does not do that. They're solely volunteers. They do provide input based on experience, but part of the work that they do is on an ongoing volunteer basis. So we offered any onboarding information, and the information that we provided was on the process of how to initiate the process to become a volunteer, as we thought that was the best way to proceed. Other than that.
Okay, is that it?
I think so.
Great, thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none. Members, I'm going to hand it off to our chair of the complaint committee to provide any additional, or at least start the ball rolling.
Yeah, can I start with questions, actually, for
Sure.
the respondent?
Mm-hmm.
Ms. Angel, can you approach? So when was the first, when was the patient advisory committee, when did they start meeting?
At the Family Health Center, the first meeting began in 2010.
Okay.
And that was solely for Spanish-speaking patients who had diabetes.
Okay. And these meetings are continuing. It's still occurring.
It changed. So at that point when they started, they were specifically for that improvement work. So Spanish-speaking patients' diabetes. And so when we worked on projects with them, it was a period for about 2 years. Excuse me. And then that worked really well.
The 2010 to 2012.
Yeah.
Were there any other meetings after 2012?
There were. It transitioned, so we opened it up to not only diabetes context, so any other improvement work that was happening at the clinic.
And so those were still patient advisory committees, but different types?
Different types, yeah,
okay.
Depending on the topic.
And those are continuing till this day?
Yes.
Okay. And there's this document that is in the packet. It's from the San Francisco Health Network, and it has information on like sample meeting minutes, things like that. Are you familiar with that document?
Yes.
Okay. And so is this document providing some instruction on at one of these other facilities, if they want to start a patient advisory committee, it shows them kind of how to have sample meeting minutes, how to have an agenda?
Yes. So
okay. And so after they have the meeting, where is the agenda?
At the coordinator, it was instruction for the coordinator at the health center to have some sort of structured meeting.
Okay. And so where is the agenda after the meeting?
It's just used during the meeting time.
Okay. And where are the minutes after the meeting?
There's no regular collection of meetings. It's more action items.
Okay, so when the minutes, like there was a sample in the packet. It says sample meeting minutes, and it's page 108 of the packet, but page 34 of the document that you provided. Yeah. So it says announcements, and then it says agenda item 1, agenda item 2, and then there's another column that says discussion, and there's another column that says actions. Are you familiar with that type of document? Okay. So where, after these boxes are filled in, where do the meeting minutes, it also says attended, like who, name of advisors and staff that attended, or date of the meeting. So where do those minutes go?
In an ideal situation, we hope that they share them with the staff or whoever's it would benefit to hear about that improvement in progress. So whether it be the leadership of the clinic or the staff, or just as a record for the next meeting to follow up on action items.
Okay, and so where would the record of that next meeting be? Would it be in a folder, in a cabinet? Okay, because what I'm getting at is the petitioner asked for those minutes and he didn't receive them. So why didn't you give those meeting minutes to the petitioner?
As far as I know, when it was asked, I thought it was later in that time.
Well, he requested the meeting. He requested any documents that were between, I believe, 2014 and 2018. The date of which his not 2018, 9/18/2016. The date of his request. So why weren't any of the I kind of understand that the agendas have gone missing. I don't really understand that, but the minutes you said are kept somewhere, circulated. So
possibly, if it's not a highly structured meeting, so they come together once a month. They talk about what they've been doing. They take notes. There's sometimes action items, and if there's action items, they move forward.
Okay.
So honestly, there's not a lot of structure around the minutes, and if the meetings don't get typed up, or it's more of them following up in the following month.
Okay.
I do know that at the time that summer there was a hiatus of that group was not meeting because their coordinator was on maternity leave.
So they didn't have any.
Okay. So they weren't actually meeting for the summer. I do apologize if there wasn't timely feedback around on that point. But usually I think our response was, if there was interest in the advisory council, our response was to, if you want to be involved, here's the volunteer process for it.
Okay. I don't have any more questions. Does anyone else have any questions? I think I kind of know where I am now.
Say, Member Hinsey.
So, am I correct in stating that are you saying that there are no agendas for these meetings? There are no formal agendas that are handed out to members, or?
They don't always come out in advance, so the agendas might be created at the meeting themselves based on what they have to talk about or what they want to discuss. But it's not an official agenda.
So someone must have something then after the meeting that constitutes something of an agenda, right?
Excuse me?
Someone must have something then at some point that constitutes a meeting agenda, right? Whether it's made up on the fly or it comes out in advance.
Sure.
Is it your understanding that there's no process for keeping that agenda after the meeting?
Not currently, no.
Vice Chair Harlan.
So just catching up, I know you guys are there, the complaints committee. What I'm kind of hearing is this a passive meeting body or is this a formal meeting body? And that would kind of determine, I think, what kind of direction we can take. It certainly sounds like whatever they are, they're not very organized. And I think our decision will rest on what kind of animal is this, and that will allow us to move forward, I think.
Yes, at the complaint committee, I don't believe that we had anyone from the respondent present, so it was very difficult for us to gain some of that information. I think that the petitioner has done a good job of explaining, why this body meets the requirements for needing to provide agendas, minutes, things of that nature, and it's a bit more clear to me now after being able to hear from both sides. On what needs to happen going forward.
Member Kanata, did you have something?
For the complainant, could you come up, please?
Anonymous.
Anonymous? So you filed your IDR on September 18th. When was the first time you got a response?
Well, with all due respect, I don't remember. All I know is I think they're in violation for not keeping and sending me the copies of the agenda and the minutes. And by the way, the Sunshine Ordinance classifies advisory bodies as passive and covered under the law. If that isn't clear, if you need, I could pinpoint the section. So it is under your jurisdiction, and they're in violation for not keeping records. These bodies have been falling apart, and they're secret. They're effectively secret. They don't have any accountability. There's no agendas. There's no minutes. You have no idea what happened there.
Yeah, thank you.
I hope you don't let them get away with it.
Thank you.
I can help with answering the
Blatant.
question. Is that I'm not saying that the documentation provided is what was requested, but on September 27th, in the packet, you can see where I believe it's Ms. Angel or someone else from the clinic sent over the information that's in the packet, which was just like this generic packet that had sample agendas, sample ways of engaging people to be volunteers, sample, how to keep minutes, and it really explains kind of if a facility wants to start a patient advisory council, it gives them kind of all of the steps, but it's not the actually specific agenda or minutes. So September 27th is when something was sent,
and that's on
but it was
page-
also an IDR, so keep that in mind. So even though that was 9 days, we are in an IDR situation. So
Maybe Vice Chair Highland.
So it sounds like
immediate
me.
disclosure request.
Sounds like me. This is probably something that will probably best end up at EOTC. For
That's education, outreach, and
training committee, because clearly this is you seem unfamiliar with. And sorry, could you state who's the custodian of records for DPH? Do you know that?
That's Nancy Saraya.
It is okay.
The Nancy Soraya sent you here.
Not today. So this was filed. This had been filed previously, and then it was dropped, and then it was refiled, I believe, which is why I'm here. So we originally had intended to come to an original hearing a few months before, like last year sometime.
Yeah, there was she might be referencing the complaint committee subcommittee hearing of
That
this.
was the 20th.
Of December.
Yeah, before that. This had been filed previously.
That's the first time I saw it.
It was previously filed, but it never came before the task force because it was withdrawn.
Okay.
So the response that you received was the second response that was made.
Okay. Any other questions? Vice Chair Highland.
So just thinking out loud. I mean, obviously there's some violations here. If this is indeed a meeting body that should be noticing agendas, minutes, etc. So I think we should probably sort out whether we think that's the case.
Well, I'll just quickly, in section 67.4, under passive meetings, section A5 states gatherings subject to this subsection include the following, advisory committees or other multi-member bodies created in writing or by initiative of or otherwise primarily formed or existing to serve as a non-governmental advisor to a member of a policy body, the mayor, the city administrator, a department head, or any elective officer, and social, recreational, or ceremonial occasions sponsored or organized by or for a policy body to which a majority of the body has been invited. The subsection shall not apply to a committee which consists solely of employees of the city and county of San Francisco. So that's kind of the description with regards to how advisory bodies would be referred to in this case. So I have a question for you. So this particular body, does it report to anybody? Who does it advise, actually?
So the coordinator at the clinic. So if that varies at the Family Health Center. It's a combination of our QI analyst, our quality improvement analyst, and a provider who is involved in quality improvement. So they are, I guess, responsible for looking at the data that the clinic has and identifying areas for improvement.
So again, this particular section speaks to an advisory committee that could be a non-governmental advisor to a member of a policy body, the mayor, the city administrator, a department head, or any elective officer. It's only 5. Okay? So the question is does this, if you first have to define whether the advisory body is applicable to obey or comply with the ordinance, we first have to, I think we have to determine whether the body requires that. So unless there's somebody has some other point in this, DCA COLA, do you concur that this is the section that defines that?
On what defines the hazard meeting?
Well, no, what defines this particular body, this advisory body, committee? I mean, we can't make a determination on violation unless this particular body is required to comply with the ordinance or not. So the first question is this this kind of advisory committee? The question I have really is, that's why I asked, who does it advise?
Mm-hmm.
If it advise,
We weren't at the complaint committee, so that's why we wanted to explain that. Yeah.
And if that person, I guess if the person isn't here to answer that question, it may give us good cause to continue the item and request that person to attend so we can find out. I mean, the question ultimately, does this person advise Ms. Soraya at all?
No.
Okay.
She's the custodian of records, but
Okay.
she's not the department head.
Got it. Okay. Of course, you're right.
No.
Of course, so you're
And in your department's response to this complaint, you stated that these meetings aren't open to the public?
Yeah, we see them as volunteer meetings for the purpose of quality improvement.
What's the basis of not opening to the public, though?
Just in terms of the structure, we haven't ever opened it to the public.
Okay. And if a member of the public wanted to attend, would they be able to?
I believe that it has been done. I believe that he was done. Did attend a meeting talking about wanting to provide input for the changing of Muni. I believe that the response to that was that that body didn't have any influence over changing Muni lines or not. So that was not a matter that they could support necessarily or have any input on.
So, are there members of the public that regularly attend a meeting?
Other than the volunteers, no.
Did these volunteers that attend sign any sort of waiver of confidentiality about what's discussed?
Yes, through the volunteer process. So they go through a HIPAA training, confidentiality.
So HIPAA issues are discussed at these meetings?
Excuse me?
So there's HIPAA or confidential issues or subject matter that are discussed at the meetings?
Maybe their own. Not necessarily ours. All our volunteers sign compliance, go through the training. So we just consider it standard process. The only other matter is sometimes they'll stuff envelopes that might have patient names on it, which is why so volunteer tasks that might have them kind of encounter what we consider PHI.
Okay. Vice Chair Hyland, before you ask your next question, DCA COLA.
That's okay.
Vice Chair Hyland.
DCA COLA covered my question.
Okay. You got it? Okay.
That's all I got.
All right. And so, what's your conclusion from your line of question? Well, we're asking for some counsel, some advice, so.
We hope to see it in your memo earlier, but.
I mean, I
take into consideration the subject matter that they discuss in these meetings, and that anyone that attends these meetings has to sign a confidentiality waiver, and I mean, there's a potential for people attending these meetings to find out confidential medical information about patients. Take that into account, considering whether or not you think this is a public meeting. If anything, it sounds like maybe they didn't receive the facts, or they didn't respond to the facts in a timely manner. But beyond that, think about what the complainant was asking for, and is that subject matter that's disclosable.
I mean,
Member testify.
I'm glad that the respondent is present today to give us some context of what these meetings were. We didn't have that at the complaint committee. But, learning about who the patient advisory committee is actually advising is very important. It gives me less pause with the way that they treat documents, particularly if it's not going towards the department head in any way.
Well,
I would like to hear from.
Let's find that out. If this person is, because the only other person in this list that would actually apply would be the department head.
Right, would be the department head. I also would like to hear from the petitioner, because he has had experience on a patient advisory committee in the past, and I think he might be able to give us some information that he might know of this information possibly going to a department head. Because I could see it sometimes going, sometimes not going. And if it ever does.
I don't think he's in the room.
He's right there.
Oh, is he? Okay, I can't see
Sorry.
him. Sorry.
So much fun.
Okay.
In my experience, yes. In many cases, department heads were present and participated in these meetings. But I have to tell you, I don't know if you've examined the packet very closely. It is highly restrictive, and in my experience, now mind you, this gets very complicated. I have not participated in these meetings except for that one that I mentioned that I think they owe us the agenda and minutes to. By the way, how in the world could having a copy of an agenda be in a violation of anybody's HIPAA rights? That's absurd. But in all the years that I participated in these meetings, and I mentioned 3 different San Francisco Health Department facilities that I participated in these meetings, and there never was any HIPAA restriction or any personal medical information exchange which would require anyone signing a confidentiality
the
agreement.
Department head, if you could speak to
Yes, I believe
the department head, or
that in some of these, at least some of these meetings, there were department heads, and the purpose was to facilitate at the highest level of each department the best operation, the most efficient communication between patient and staff, including department heads. That's my recollection. And
Thank you.
Vice Chair Howland? No?
Can we hear from the respondent on that? Just
Sure.
Can you respond to what you just learned? And I know you said that these patient advisory committees have undergone restructuring, but are department heads ever involved? Does the information only go to this analyst that you said, or
analyst? There are times when staff at the clinic, whether it be providers or management team leaders, do attend to respond to questions.
Mm-hmm.
And they might receive feedback. Beside the clinic itself, it's not usual for anyone else to attend. There's other open meetings that are part of our volunteer initiative. There's one at the San Francisco General Hospital where that's an open meeting. Where they share information about the hospital, and I do know their CEO attends that on a semi-regular basis. That one is an open meeting, though, and we don't oversee that.
Okay, so for the patient advisory committee, sometimes department heads attend.
By department, the clinic, so not like Barbara or. She wouldn't attend, no.
Okay, so
It's not a matter of who's attending, it's a matter of who the body
Advises.
specifically advises. Could be in writing, a report, or what have you.
yeah, so the recommendations that come out from the patient advisory committee, you said that they're circulated to some people. To whom are they circulated?
To the clinic. So each clinic usually has a group of staff that, as part of their administrative time, work on quality improvement. So they come together in a quality improvement committee.
Are they circulated to the Department of Public Health, the head of the Department of Public Health?
No.
Okay.
As far as I can see, reading through the handbook, so I would say starting on page 83, hour number 83, or actually page 81. What is a patient advisory council? A group of committed patients and their caregivers who meet regularly with designated clinic staff to improve clinic's operations and work on quality improvement. That's not a department head. Who utilizes? That's not applicable. Who makes up a patient advisory council? Patient advisory council members, committed volunteers, comprised of patients, family members, caregivers. Advisors help promote patient-centered care within their primary care clinic. Serving as key advisors, they inform clinic leadership on those issues that are most important to patients and family members. So it doesn't seem to me like this particular advisory committee rises to advising the department head. On the next page, 84, patient advisor is a patient or family member of a patient at a health center. Patient advisors serve as advisory resource for current and future projects on improving patient experience. Patient advisors collaborate with PAC, advisory committee, clinic champions, the coordinator, clinical management staff, and providers. So first have to define the body and then determine whether it needs to comply. So I'll leave it at that. Any other questions for either parties? Okay. Is there a motion?
Maybe.
Oh, rebuttals, I'm sorry. Yes, respondent, Ms. Angel? No rebuttal? Do you have 3 minutes for a rebuttal? Yeah.
If you don't have any, that's
You don't have to.
DC Cullen.
I think regardless of who attends the meeting, you got to look at what sort of subject matter is considered at that meeting. If you look at 67.3, what is it? B4, uppercase D, as a definition of what is not considered a meeting, proceedings at a Department of Social Services, Child Welfare Placement Committee, or similar committees which exist to consider confidential information and make decisions regarding Department of Social Service clients.
Well, they're not making, I mean, I don't think we get there. They're not making any kind of decision like that. I don't even think we get to that point if we don't consider this to be a passive meeting body. And the information that we've been able to get from Ms. Angel, I think, has given us enough information to make that determination or not.
And with regards to this particular section, it's very specific as to which department it's referring to. This is not Department of Social Services. This is the Department of Public Health. So, and that proceedings deals with child welfare placement, which is, I think it draws a different line. I think it's not. I don't think it could be considered as a general example per se. I'm not quite convinced of that, but thank you for pointing that out. Okay, a rebuttal. So let's continue with rebuttals. Ms. Angel, do you have any rebuttal? Anything else you want to say? Complainant, anonymous, do you have any rebuttals? 3 minutes.
I would draw your attention to 67.3C. Passive meeting body shall mean advisory committees created by the initiative of a member of a policy body. I believe these committees are created, quote, by the initiative of a member of a policy body. What is a member of a policy body? Who created these? I believe these actually come out of the Barbara Garcia's office, the head of the Department of Public Health. So I wouldn't. I think that these were created by a member. I'm repeating myself. That's probably the.
So let me just ask you a question then. I mean, you first cite 67.4A1.
Mm-hmm.
Okay? So if we're going to stick with that as a passive meeting, then we have to also consider A5 in the same paragraph.
Which says what?
Gatherings subject to this subsection include the following: advisory committees or other multi-member bodies created in writing or by initiative of, or other primarily formed or existing to serve as non-governmental advisor to, and there are only 5 positions that it can advise. It can only advise to a member of a policy body, the mayor, city administrator, department head, or any elective officer. It's it. Okay, and in their handbook, it describes what this particular advisory council it reports to, and it does not report to the department head. It doesn't report to any of those 5 positions.
But doesn't it report to a member of a policy body?
Which policy body? It doesn't. It doesn't state that it does. It reports to clinical staff. That's what their handbook says.
Oh boy, this is getting very confusing. I'm saying it defines a. Are you saying the other section, one section excludes the other section? Section C, 67.3C, defines, we've determined that this is a passive meeting body, right?
All this means, you're asking, when you cited 67.4A1, okay, that such gatherings need not be formally noticed, except on the city's website whenever possible. The time, place, nature of the gathering shall be disclosed upon inquiry by a member of the public, right?
Mm-hmm.
Okay, and that the information should be accessible to such inquirers as a public record. But then it goes further to describe what gatherings. It describes which.
It limits the other section.
It basically says, such gatherings, okay? That's what you were stating, okay? Then it describes what such gatherings are for this particular purpose as far as producing or complying with providing the information, okay? It's not like all the other passive meeting bodies. It actually makes it a little bit, it makes it clear about this particular kind of advisory body. That's what it, to me at least, that's the way I read it. Somebody else has a different interpretation.
So you don't believe this advisory body is covered by the ordinance?
I don't think this particular advisory body rises to that occasion because it doesn't advise those 5 particular, any one of those 5 particular.
So it not only must be it not only must meet the condition of 67.3C, but also the other section. If it doesn't meet both conditions, it doesn't apply?
Oh, just through the chair?
Yeah, when I ask a question, we pause it.
I think 67.3C is just defining what constitutes a passive meeting.
A passive body.
Passive body.
Which this is, right? This is.
This sounds like this is a passive body, but then the other article.
Yeah, let's hear the rebuttal.
Okay.
Oh, it had a question.
Right away.
And the other article defines what should be disclosed if these passive bodies, who they're reporting to, who they're advising.
Okay, let's Mr. Anonymous, would you like, you can finish your rebuttal.
Well, I don't, maybe I haven't read the ordinance closely enough, but I think it's covered. Maybe it's a question of the spirit of the law rather than the letter of the law. This body would not exist if it wasn't funded by public funds from the public treasury. If this part of this, but Department of Public Health, I mean, obviously the Department of Public Health serves the public, and which, if this isn't, maybe it's in the Brown Act, maybe it isn't in the Brown Act. I find it hard to believe that this body, which I participated in for years, to advise a publicly funded health provider, is not covered by. And the purpose of these bodies is to. I'm sorry, I just can't make. I just think it meets the spirit of the law, and perhaps it doesn't meet the letter of the law. Maybe the law needs to be revised. I don't know.
Okay, thank you. Okay, members.
I'd like to make a motion to not find a violation of 67.21B and 67.25A, which I believe are the sections that were implicated here.
Second.
Moved by Member Tesfaye, second by Member Hinsey. Public comment.
David Pilpel. Sorry to have to talk so much tonight.
Welcome.
Thank you.
No, you're not.
Interesting discussion about the nature of this body. It seems clear to me that it is not a policy body. It's an interesting question about whether it's a passive meeting body or not. It could be argued probably either way. But frankly, I think that's irrelevant. I don't think the task force needs to reach that issue, and that's not before you. The question before you is whether the immediate disclosure request on page 48 of your packet was timely and completely responded to. And I think here the answer is no, it was not. There's a timeliness violation because the documents that were provided were sent on September 27th against a request dated September 18th that I think is properly formed. The top of the fax says immediate disclosure request. Those are the key words. It's there. So I think that a violation of 67.25A is the first order of business. The second question in my mind is whether it was completely responded to, and I think there again the answer is no. The request was for all communications and documents related to the Family Health Center Patient Advisory Committee for the period January 1, 2014 up to and including September 18, 2016. What was provided was general information about the patient advisory councils or committees, which is very interesting stuff, but it's not specific to that time period. So whether or not the agendas were cooked up beforehand or come up with during the meeting, whether the meeting notes were ever typed up, whether they were translated into Spanish or not relevant. If there are any meeting notes, communications that, in my mind, includes emails to members saying we've got a meeting coming up next week, we're going to talk about blah, blah, blah. All of those should be produced. You should ask the department to send a communication to Mr. Anonymous and state that they're going to do a further search. If there are documents that need to be redacted pursuant to 6252C or 6252K because of HIPAA or medical file appropriate redactions, those redactions should occur prior to release of the documents. But it appears to me that there are likely additional documents that weren't found in the initial search. The response from the department refers to a different case number, 160055, and this is 16092. So that's my position, is that you should find a violation of 21A and 25A, ask the department to do a further search, redact documents as appropriate, and provide them to Mr. Anonymous. Unless you have questions? Thanks. I guess I have to be more brief when I'm making public comment. Darn it. Thanks.
Any other public comment? Seeing none. members. So the public commenter on the face, I think, is convincing to me, but still, I think, if anything, the response from that may or should have come from the person who was Dr. Lydia Lung from DPH, that the response would have been that this particular body doesn't rise to comply, so there's no need for us to release or for them release any documents, whether or not there was procedures to have them or not. I think the public commenter's position is that this is a legal body that was required to comply under the ordinance. My contention is that it's not. But I think on the face of the IDR, I think the IDR, first question is was it complied to properly within the proper time? And second, was there a conclusion to it? And I think that's where I think we have to make a decision on at this point. Whether to find no violation for those particular sections.
I'm open to an amendment of the original motion, similar to what you're stating. The amendment being that there should have been a response to the IDR saying that we won't be turning things over, but that response should have come within the statutory deadline.
Refresh my memory, was there a response from the respondent to the...
On 9/18 was the date of the request, and on 9/27, this packet of materials that we've been looking at were provided on 9/27, but that's still not within the IDR timeline.
So,
Member Canada.
Just for my clarification, how can we find a violation if this passive body does not come under?
Because if you look at it, just take the IDR. Okay, did Ms. Leung comply with the IDR in time frame alone, in either response or time frame alone?
No, my opinion is, my feeling is that if this passive body comes under sunshine, there are violations.
Right, I understand that, but the first question is whether the IDR was complied with properly or not what information should have been passed on. That would be secondary. I think primary, needs to be, a response needs to be made within by the end of the next business day. And
under the Sunshine Ordinance.
That's right.
But if the body doesn't...
But the request wasn't made to the body. The request was made to the director of the Family Health Center, who is a city employee. So that's the question here, is whether that respondent complied with the IDR or not. Not whether the information that was provided was correct or not, or was required to be in compliance or not. That's not necessarily in contention here. I think what's in contention here by the complainant is that the IDR wasn't complied with within a proper period of time. So I would amend the motion to find in violation of 6725 for not responding within the immediate period of time, notwithstanding whatever documents the respondent, the complainant received.
The chair, even if there's no documents that were responsive to the request?
Right. Look at the first challenge of the IDR is, did they respond accordingly? That's the first challenge. Whether or not their documents were given or not later, did they respond within the first 24 hours or less if it's the next business day? That's the first thing. And if they did they then provide any documents accordingly? Did they ask for an extension because it was voluminous or what have you? So on and so on. I think it's kind of, it goes in a series of events at this point. So that's my contention. So I would I'll make the motion. I move to amend as a replacement motion to find a violation of 6725 back. Hold on, let me get to my 6725. Yes, 6725A. And as to whether the documents themselves were responsive or not, that's a second question. So that's my motion. Is there a second?
This is to the amendment?
Yeah, I'm making a replacement motion. I'm amending. Sorry?
You're making a replacement motion? Okay. Sure. Second.
Okay. Moved by the chair, Wolf, second by Member Hensey. Comments? Public comment?
Could you reread the motion?
The motion is to find a violation of 67.25 for failure to respond in a timely manner to the immediate disclosure request.
All right, I can live with that.
Public comment.
Peter Warfield, we're not a party to this and are not particularly familiar with this, other than to say that the whole question of what's a passive meeting body, I consider to be a nightmare that needs to be cleared up for folks. But to speak to the discussion that's occurred, I think you need to be very clear. Any person can make a request for information that's public information, and basically any information that's held by the government or a government agency or a government agent is public. Whether it's disclosable, fully or partially disclosable, that's another question. But public information has to be provided according to the rules of sunshine, which require responsiveness to information requests. It doesn't matter whether it's no kind of a meeting body. I can ask city librarian and have done so. Deputy city librarian, any person who's in any position. It doesn't have to be a meeting, it doesn't have to be a passive or any other kind of a meeting body. Those records are subject to being requested, and there has to be a proper response, and if necessary, justification for partial or full redaction. So I think that's very important. These seem to me to be parallel tracks that don't meet. An information request was made. Was it responded to? It's not relevant who it's made to or under what circumstances. Was it made in accordance with the requirements? Was it satisfied? That should be the only question here. And so I would urge you to support the amended or the chair's motion on this. Thank you.
You've invited further public comment, so David Pilpel, to clarify my earlier points. Victor, you want to reset the time? Thanks. I agree, it matters not at all whether this body is a passive meeting body or not. If the department didn't properly respond, then they get, unfortunately, dinged for that. If they have any records responsive for that 2.5-year period, they need to say, we have these records that are responsive. If they need to be redacted, they should be redacted, but they need to be provided. I understand this is probably Ms. Angel's first time here, and Sunshine is probably not something she knew about or was too familiar with beforehand. That's fine. She needs to consult with Ms. Soraya and with their deputy city attorney. I don't even know who it is on the health team anymore, but whoever it is needs to review this request carefully and craft an appropriate response to the requester. There is a 25A violation, in my opinion. There's also a 21A violation for failure to disclose the information that was requested. 25A is only as to the timeliness. 21A is as to the content. So I believe that there are documents, I believe, that exist relative to this body for a 2.5-year period, or the department can just say, we have no records for this body for that period. I think that's unlikely, but they haven't said that. And so they have not conducted their diligent search and reported that back to the complainant. Again, you should find a 25A and a 21A violation. The department should act accordingly, and you should refer this to committee for follow-up.
I'm just going to take 1 minute, okay, just to connect with you on this for a second. First of all, 6725A states that a written request for information described in any category of non-exempt public information shall be satisfied no later than the close of business on the day following. So 6725 does include the presentation of the information in the same way 6721 does.
Okay, that may be. The way we've previously interpreted it was that 25A referred to timeliness and 21 was as to content.
I got you. Whether or not the documents are disclosable or not, the question is does this body require this particular advisory committee required to keep any documents at all? And because of the way its nature and the way it's described in the ordinance.
I appreciate the question, and my answer is as follows. If it is a passive meeting body, then there are additional requirements under 67.3, 67.4 as to how that body's conduct is reported and that agendas are available and meetings are open and all of that stuff. As to records, whatever records exist are subject to disclosure, probably with redactions. And if they say, well, we didn't keep stuff, then you have to look to the department's record retention policy, which I'm sure will require at least a 2-year minimum retention period for any document not otherwise described.
So you're just saying that any and all information is public, whether or not it's required to...
Right.
But okay, go ahead.
I recently attended a police committee community advisory board meeting in a neighborhood police station that I'm sure was not set up by the police chief and was discussing some sensitive information, so I left it at some point. That, I'm not getting into what that body is, but you can discuss sensitive things and be subject to confidentiality, et cetera. That's not really the issue. They need to disclose what they have and redact as appropriate.
Okay, thank you very much.
Further questions? Thanks.
Okay, any other public comment? Seeing none. Anything else for the good? Okay. Please call the roll.
On the motion, find a violation of 67.25A.
Also, let's refer this to, what do you suggest?
Originally, I thought UTC, but...
Let's do it to compliance. Let's refer this to compliance and amendments.
But I was going to say it. I'm not sure it requires...
I think it needs further interpretation to figure out what's...
And what are the directions for the compliance and amendments?
To disclose whether or not to disclose the information. And they need to come and either, report whether the information is disclosable or not, so on and so forth.
If it is disclosable, whether...
Well, then you just report back to us if we need to take any further action.
This matter is to refer the matter to the Compliance and Amendments Committee with request to the department to disclose whether or not they have additional records that...
To disclose the records.
To disclose the records.
Or provide reason as to why not.
Yes.
We're deciding where to send it before we voted?
As part of the motion.
Part of the motion.
Okay.
On that motion,
Read it, please.
the motion
Thank
is
you.
find a violation of 67.25 in regards to the timeliness of the response to the immediate disclosure request, and to refer the matter to the Compliance and Amendments Committee with instructions to the department to disclose any additional records in response to the immediate disclosure request, and or provide responses that documents need to be should be redacted or are non-disclosable or do not exist.
So through the chair, part of this motion, if it gets voted on, is that then this department has to come to this committee meeting and be instructed on what to do? Is that what we're doing?
We're asking them to provide additional information
Okay.
Regarding other possible records that may exist or not exist.
And the Compliance Committee will determine if they've complied appropriately or not.
And I will work with the department and
Okay.
try to assist them in doing this.
Okay, that's it.
On that motion, Member Barnetsky.
Aye.
Barnetsky, aye. Eldon, excuse. Wolf, excuse. Copra, absent. Member Tesfa.
Aye.
Tesfa, aye. Member Moss, excuse. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, we'll take a 5-minute recess.
Take you outside.
Back to order, please. Okay, let's call the next item.
Next on the agenda is item number 7, file number 16106. Complaint filed by Anonymous against Andrew Perry, Ann Brash, and the Planning Department for allegedly violating Administrative Code Section 67.218 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Okay, let's jurisdiction.
So moved.
Second.
Moved by Vice Chair Hyland, second by Member Kanata. Any discussion on jurisdiction, public comment on jurisdiction? Seeing no public comment, we take it by acclamation. Seeing no objection, the item is moved by acclamation. Member testify. Start the ball rolling.
Yeah, on this item, we found that there was a violation, but what we were able to learn was that the requester seemed to get to get the information that she needed, but the violation was really of 67.21C for failing to assist a requester in identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the department. After looking through the packet and seeing the back and forth between the petitioner and the department here, they just really weren't very helpful with all of the information that she was trying to get. There were a number of items that she was trying to get about the exterior expansion of a specific property on Hyde Street, and they really could have offered to provide all the documents relating to the expansion rather than this piecemeal approach that wasn't helpful to an unsophisticated requester. So the violation here, we did find that she had found all the documents. It was for 67.21C.
Okay. All right. Well, I would hold your conclusions, but just to make sure you have all the documents, you presented it.
Yes.
Properly. Okay, great. I just for a notation to the general public and to all the parties, we're going to have the complaint committee summarize what they had heard in the complaint committee, because they're the most knowledgeable about the complaint in collecting the information and making sure that both parties are in agreement with how the committee understands the case. And then we'll move to hear testimony from each of the parties. So that way, at least the task force members have a clear idea from its own members of what the case is about. Okay, the complainant, Anonymous.
I don't think she's here.
Are you in the room? Okay, we're going to, should we continue with the case?
Victor, did you hear from Ms. Sang? I mean, she's
I don't
been
believe this
here
one
many
is the
times.
Missang case.
In the
This
pa-
is a different
Okay, if
person.
it's anonymous, please don't mention the person's name.
Well, and on item 7, you can see her name is it's in multiple parts of the packet,
Okay.
unless I'm looking at the wrong item.
I think you're reviewing the wrong item. This is
16106.
16106, in which they requested from the planning department the checklist used for determining certain planning issues. And then we instructed the planning department to provide an entire copy of the DR file to the complainant.
Are we on item 7?
Yes.
Yes.
Okay, I guess I can see I can see that name, her name on here. But
You do or don't?
I do,
Okay.
but I'm not going to go.
But let's not assume that that's the person. But is anonymous for case number 16106 present in the room? Okay. Seeing not, members, do you want to move ahead with this case?
Did you hear anything from Anonymous Victor about?
I have not received any additional information. I did provide notice to the parties.
I ask again, members, do you want to proceed?
Proceed.
Is there someone from planning here?
Yes.
Yes.
I see the
There
respondent.
is, respondent is here.
What? She did, yeah. That's why I know what she looks like. She's not here.
Do you feel that the information that was presented by Anonymous is sufficient to move the case forward?
Only for the section that I stipulated, yes.
Okay. Proceed? Okay. Are there any persons or witnesses on behalf of the complainant to provide any facts or evidence? Seeing none. Respondent, 5 minutes.
Good evening, Chair and members of the task force, Christine Silva, planning staff. And just to clarify, we have 2 separate complaints, one by Ellen Sang and then one, the original requester, Mr. James Russell, which is this complaint. So on Thursday, October 13th, 2016, the Planning Department received an immediate disclosure request via email from James Russell requesting records of the sections of the Planning Code that the Planning Department applied to a project at 265052 Hyde Street. That same day, planning staff Andrew Perry responded to Mr. Russell's request, attaching a blank residential plan check sheet, which is pages 140 to 143 of your packet, indicating to Mr. Russell that the sheet contained hyperlinks to every planning code section that applies to projects in residential zoning districts, such as the one in question, and is the form that staff uses to review projects for compliance with the planning code. Mr. Russell replied back that afternoon indicating that the provided record was not the record he requested, requesting instead that a filled-in plan check sheet be sent to him. The following day, October 14th, Mr. Perry responded to the email indicating that a filled-in planning check sheet did not exist and was not required to be filled out for every project. That simply is a tool to use, that planners use in their review. At that time, staff considered the request complete. An email from Mr. Russell on October 19th alleged that the request was still active. However, staff disagrees and believes that the plan check sheet provided on October 13th was responsive to the request. As such, the relevant document has been provided to the requester accordingly and in a timely manner. Happy to answer any questions.
Thank you. Any persons or members of the public provide any witness, provide any facts or evidence on behalf of the respondent? Seeing none. Okay, members? Questions? Clarifications? So Ms. Silva? Sorry. Can you, I'm sorry, point to the page that of the document that you feel that you have fulfilled?
Yes, so it's pages 140, 143 of your packet. It appears as an Excel file. So this checklist is used by our planning staff, and it has hyperlinks of all the planning code sections we would look at when reviewing a project, and this one's specifically for residential projects.
Okay, and do you feel that this particular document is the document that the requester was specifying?
Yes, so in his original request, he asked for the sections of the planning code that we applied to this project on Hyde Street. This document would be the most direct way to point him to those planning code sections.
Well, I'm looking on page 129. Oh, no, I'm sorry. That's not the original one.
Through the chair.
Yes.
Ms. Silva, just a point of order. Going forward, probably better to refer to the complainant as the complainant, not his name, because there is a wish.
Be anonymous.
Yeah.
You can either use the word complainant or petitioner.
Okay.
Either one. Okay, so... All right, so I think it's up on page 128 is the first one. This is a general blank sheet, not a public record. I requested. Okay. So when he said that, this is a general blank sheet, is this the document that you're referring to?
Yes.
Why is he saying that it's a blank sheet?
If planners do decide to use it and fill it in, there would otherwise be comments in all of these blank.
Is there a requirement to use this?
No. There's not a requirement to fill it out.
Member Kanata and then Member Tesfaye.
So, Ms. Silva, in his request, he specifically asks for the sections of the planning code that were applied to 2650 to 2652 Hyde Street. Is that not available anywhere? In other words, the planning department has to have some files on this project. Sending him this sheet, how would the petitioner know which of these codes apply to this project?
So this particular sheet applies to any project in a residential district. We have separate sheets for projects that are in commercial districts, neighborhood commercial districts, etc.
Okay,
when the planner replied, he said this is a sheet we use for residential districts,
right,
which the Hyde Street address is located in, and this project would be applicable to.
So you're saying that every project in a residential district uses all of these codes?
Correct. We would go through and see if these were applicable. This is our starting point.
Exactly. That's what I'm saying. This is your starting point, but he wants the ones that were applied to this address. He didn't ask for every code that could be applied. So, again, my question is, does the planning department have a file on 2650 to 2652 Hyde Street that has the codes that were applied to that project? And if so, why weren't they just sent to the petitioner?
In that case, the planner did not fill out this sheet, and so we would not have a responsive record that shows, whether or not yes or no, the planner looked at every single one and applied it to this project.
We'll come back to you. Member Tesfaye, then Member Vice Chair Hyland.
Yeah, just to fill in a little bit from being at the committee and reviewing the packet initially, was that what was provided to him is what they had, but they should have explained that not every planner used. So he didn't say that they gave him a blank piece of paper. He said they gave him a checklist that was not filled out. And so, which is what they had, because not every planner fills out the checklist. They're just using it as a guide. And so that's why I know I'm supposed to not lead you to a conclusion, but why when we referred this, we were seeing that he did receive what the information, the checklist, but that a filled out one didn't exist, and that's why we were leaning towards 6721C for failing to assist the requester in identifying, maybe he should be asking for the complete file on that property or something like that. That might have helped him in whatever we don't know what his end game is, but they should have provided that information. But they did provide him with what he asked for.
Okay. Vice Chair Hyland.
Ms. Silva, is there not a way that you can just throw in the address 2650 Hyde Street and come up with all documents which are related or correlated to that address going back into time immemorial, like you can with DBI? Does that not exist in the
So
planning?
we do have the San Francisco Property Information Map where you can put in an address and it'll show you what planning projects are associated with the property.
Active and past projects,
Correct.
the different inspections, all that kind of stuff would be in there, right?
Yes, and I will say we did do a separate request for the same complainant where he did request the entire docket and we did provide that to him. That was last winter.
Okay, so this complainant has, made previous requests which you've fulfilled.
Correct.
Okay.
Member Kanata, do you want to continue?
No.
Okay.
I'm fine.
All right, so your contention or your testimony is that that this particular plan check is not required for use.
The sheet itself.
The sheet,
Just a template. Yeah.
Okay, but is a plan check required?
Yes, so every project needs to be reviewed against the planning code to determine that it's in compliance.
Okay, and what do you use if the form that is included in our package is not required to be used? Is there some other form or some other report that gets written? Is something written down at all?
So in this case, it's associated, my understanding, it's associated with a variance request. So in the variance request materials, because there is a variance hearing that occurs, and then there's a determination by our zoning administrator. There is a variance decision letter, I believe that's what it's called, that gets issued that talks about the project.
Okay. Vice Chair Hyland.
So just to follow up on Chair Wolf's question there, it seems to me that, okay, so this person has interacted with your department before. They've asked for documents pertinent to that address. You've supplied that in the past. They then asked for this, this further request where you provided the template which this particular planner did not use. But could someone not have just done a quick search to see there's a variance document, there's this document, and then maybe checked off in the template, these are the active areas pertaining to this address, use the hyperlinks, go in, and then you can find the information you're looking for. Could that not have been done?
Yes, they could have used the property information map to find information for this one.
Yeah,
your people could have found the property information map. Is that's what I'm trying to. I mean, how hard would it have been for them to say, okay, here's a template we use. In this case, the planner didn't use it, so there's nothing filled out. But a quick search of our database shows that this, and this section has documents in it. Use the hyperlinks, and you can find what you're looking for there.
Well, in this case, he was asking for the sections of the planning code, so I'm not sure I'm understanding the question correctly.
Let's go with that. Okay? He was asking for the sections of the planning code. That's what his original IDR said. He didn't necessarily ask for this document. He asked for the sections of the planning code that are applicable, that are applied to that particular address.
Correct.
Okay? So where did you provide him those?
So we provided the checklist as a PDF, and in the checklist there are hyperlinks to every section of the planning code. And in our email we said that this spreadsheet has this hyperlinks for the planning code, so he would just click on the hyperlink and it would direct him
I understand
directly
that,
to
but
that
it's
section.
okay. Maybe. Then I have another question. Did you understand the requester to be asking for the compendium of all planning codes that apply to an address, or did you understand to be asking for which specific codes were being applied to that particular address?
To us, we look to the zoning district.
That wasn't my question.
Okay.
Okay, my question is very simple. Were you looking to just provide them with like the entire planning code because it all applies? Or did you understand to be asking for which ones did they find to be applicable? Which specific codes did they find to be applicable?
The second one,
Okay.
point to the specific points. These are the code sections specific to residential zoning districts.
But to this address, no, we're just talking about this address, not to all residential. just to this address, which ones, so on this sheet, everything that has a hyperlink, everything that has an underlined in it, is all the codes that apply to that property?
Correct.
Okay, thank you.
And through the chair, just to go back, I mean, looking at his IDR, he writes, please provide the public
What
records.
page, which one? There are a number of responses he's made.
No, the original IDR.
Okay.
Where he's, of October 13th, he says, please provide the public records, and then goes into break that out into the sections of planning code that the department applied to 265052 Hyde Street.
Okay.
I think that's a pretty well delineated request that he's asking for public records, So I think the response should at least had a link to those public records, if not the public records themselves, preferably, rather than, and you get points for saying, go here because you can find it, but I think since those are public records that could have been pullable by your department, why not just do that? I mean,
You mean the specific planning code sections?
no, the public records pertinent to 2650-52 Hyde. Period. All public records that the planning department holds for that address.
We read it to mean the planning code sections, not the entire document.
His request only asks for the...
No.
Colon there.
Yeah, but...
Provide the public records, colon.
And then he...
Ones, the sections.
Which ones he wants. Member Tesfaye, let me ask you, because...
I'm reading that differently.
The complainant was there at the complaint committee?
Yeah, I'm flashing on the fact that maybe he wasn't there.
The reason why I'm asking is what was your take on what he was asking for?
Yeah. So my take was based on what I read in the packet, because I thought that his request was very clear, that it was for the sections of the planning code and the planning that the planning department applied to 2650-52 Hyde Street,
Okay.
and which is why we led to that conclusion. You may draw another conclusion, but because it's a residential property, all of those planning code sections apply, and so they provided that link.
Yep, but this is not semantics, okay? There's a very specific difference between, like, all the codes apply.
Not all the codes, only the codes for a residential
I understand,
building.
but it's one thing, okay, for a residential building, these particular compendium of codes apply. But if it was my building and something was working out, I want to know if you found a violation of something, which code did you apply to find that violation?
That point is taken, and that's what led us to 67.21C.
Okay, so
and that they should have been more helpful with that, and that's really, and I agree with that. I just think that on the face of the complaint, they provided what they needed to provide, but they should have, in the spirit of 67.21C, they should have said, maybe here is the file on all of the, inspections or whatever. I don't know what his project is or what he's trying to do.
Okay.
But they could have provided that.
Okay, Member Kanata.
Yeah, the way I read it, and I'm reading it here word for word, he's not asking what sections of the planning code apply. He's asking the sections of the planning code that the planning department applied to this address. Not which codes apply to residential. What was applied against this address?
So, hold on. Ms. Silva, do you follow our
Trying
thought?
to. I mean, yes.
Do you understand where we're all kind of in agreement here about the way we read his request?
I think I might not be in agreement just because of when I go through a permit of some kind for my work, I have to go through all of the codes that apply to that type of a project.
No, I know, but then the question here he's asking is which ones did you apply?
Right.
After you review all the compendium of codes, which ones did you finally come up with that you applied to that particular permit?
That's not how I read that sentence.
Well,
the sections of the, I mean, I can vote separately.
the section of the planning code that the planning department, the planner, the person, the people that are reviewing it actually applied. Which codes did they apply it to?
All of the codes for residential.
Okay. All right. I guess that'll come up in a vote. Okay. Any other questions, clarifications? Okay. Let's get rebuttal. You have 3 minutes for rebuttal.
No response.
No, okay. Does the complainant happen to walk in the door? No? Okay, thank you very much, Ms. Silver. Okay, is there a motion?
I'll make a motion to find a violation of Section 67.21C for failing to assist a requester and identifying the existence, form, and nature of any records or information maintained by, available to, or in the custody of the department.
Second.
Moved by Member Tesfaye, seconded by Member Hinsey. Public comment. Seeing no public comment. Any other comments, members? I'm going to refer this to compliance and amendments and order that the planning department work with the complainant to track down exactly which codes he's looking for, the information he's looking for. Help him.
To provide assistance to determine which codes are being requested.
Or maybe any other information, too.
Okay.
Which code and other documents.
All public records.
Okay.
Can we stipulate that when it comes to compliance and amendments, that the complainant be there?
Just point of order. Should we not take a vote and then fine-tune this piece after? Once it is a violation, and then it has just for.
No problem. Call the roll.
On that motion, Member Barnetsky.
Aye.
Barnetsky, aye. Eldon, excuse.
Try not to call the same person, remember?
Yes.
Flip them around.
I will try.
Yeah.
Eldon, excuse. Joss Wolf, excuse. Copra, absent. Moss, excuse. Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay, so clarification, please send a request to the complainant to attend the Compliance and Amendments Committee. Okay, and if they don't show up, then it's dropped. That part's dropped. Okay. Okay, next item.
Next on the agenda, item number 8, file number 16107, complaint filed by the Library Users Associations against Director Ed Reskin, San Francisco Municipal Transportation Authority, for allegedly violating Administrative Code Section 67.21 by failing to respond to requests for public records in a timely and/or complete manner.
Okay.
Something that didn't really come up during the complaint committee.
Oh, wait,
but that
let's do, jurisdiction first.
Okay.
Okay. Is there a motion for jurisdiction?
So moved.
Second.
Moved by Hinsey, second by Fisher. Public comment on jurisdiction. Seeing none, can we take this by acclamation? Seeing no objection, item has been approved. Okay. Fire away.
Something that I would like to bring up for discussion before we get started on this item is in potential notice issues where Director Ed Reskin is named in this item, but I don't know if any of the verbal requests were directed at Director Reskin. Is this a concern for anyone but myself?
Due process.
Same.
Perhaps DCA COLA can give us some advice on maybe how to proceed, just to make sure we don't have any due process violations.
Before he answers, Vice Chair Hyland.
I think what would be helpful, maybe just for the record, if nothing else, is when subcommittee chairs present the case, just a bit of quick summary on what it was, and then get to this kind of a question or whatnot. Just
Sure.
a little preamble. Yeah.
Sure. You want to go ahead?
Sure. And of course, the petitioner and respondent may correct anything that I may leave out. But what appeared at the committee was that the petitioner here, I believe it's the Library Users Association, directed some questions verbally to Mr. Tajo Janda, as well as a couple of other folks. I believe Mr. Jana Rahan, Mr. Kennedy, Mr. White, that were committed orally and were not responded to in a timely fashion. That's what basically was going on at the committee. We were able to see that the SFMTA acknowledged that the oral request to Mr. Tajo Janda did not come in a timely manner. But a question that we were really struggling with were, when there's a verbal request, kind of what, and no physical evidence to track a complaint, what we should be relying on. That was a main question for us. So though we found jurisdiction, we were struggling to figure out, what we wanted to hear from the full task force when there's a verbal request to staff members and there's no physical evidence to review, and the person who was said to receive the request doesn't recall having received the verbal request. What should we be relying on? What should our standing policy be on those? So.
Okay, and your question to DC Acola?
The question to DC Acola is that the respondent that is named in this complaint, we have Director Ed Reskin, and none of these verbal requests were directed at Ed Reskin. And so kind of concerned about notice and if the correct party was named in this item.
A complainant's entitled to name whoever they want in a complaint, really. And it's sort of a common issue where they like to name a department head because if they're successful here and they want to refer to ethics, ethics requires that the department head is named for them to move forward with any sort of willful violation on behalf of the department. So yeah, they're allowed to name whoever they want as a complainant. And I don't think there's any due process concern because once a complaint is filed, notice is provided to every named party there. So if Director Reskin wanted to appear here today or wanted to provide a response on his behalf, he was given ample notice to do so.
Okay, thank you.
Okay, so let's hear from the parties. The complainant, Mr. Warfield, I think, Library Users Association. Is he here? Oh, there you go.
I missed the very beginning of this, so what did I miss?
When did you come in?
I came in when I heard some of the discussion about what puzzled you at the meeting.
Oh, yes.
Some of the issues.
So that was the.
Yeah, why don't you state your case and then it'll help clarify what the complaint can be. She was just giving a summary.
Normally you look and see whether the person is present. I was present the whole meeting and walked out thinking that for a moment I had to go out of the room, and I thought that there was going to be the previous item for some time. And so I missed the beginning of this. I don't know what issues were had
what I was
by the
saying was we have a new procedure that we've discussed with the chair where the complaint committee chair will give a brief explanation of the case. And the way I started was that I might be missing some facts or something like that, and that both the respondent and the complainant can fill in those facts during their presentation.
5 minutes.
Okay. So I'm Peter Warfield, Executive Director of Library Users Association. I did listen to the recording of the complaint committee, and I was disappointed because it seemed as though our complaint letter had not been read. So let me just give a brief summary and maybe read the letter, okay? On the morning of Friday, the 14th of October, on 1 hour notice from another member of Library Users Association, I learned there was to be a meeting of the San Francisco MTA, I'm not sure what they call it, engineering committee or something like that, and there was an item on the agenda related to the so-called 7th and 8th Street safety project. And this concerned me a great deal as a library user advocate because it included the planned rerouting of the 19 Polk Street bus northbound to skip entirely the 3 stops closest to the main library. So we went to the meeting. I got there, I believe, before the beginning of the meeting, and I was not seeing any explanatory documents whatsoever. So I went to the 2 gentlemen who were running the meeting, and I said that I'd like to see explanatory documents. And they said, well, you know, when the time comes, they'll be available. And I said, well, what do you have there in front of you? Because I believe it was Mr. Hanrahan who had some materials. So I said, I'd like to see those. And he basically said, when the time comes, we'll bring those out. Before the presentation was made by the person who's apparently doing the planning of this, I got to speak with him outside in the hallway, as I mentioned in my letter, and that was Will Tabahonda. So we talked about the plans and his presentation, and I also was interested in the loading statistics because there was talk about how frequently used these are and so on. So I requested basically the boarding statistics and perhaps the presentation. I spoke with the folks I talked during public comment and after the meeting, requesting particular information, and then later in the afternoon went to the headquarters where I spoke with Sean Kennedy and made specific requests having to do with certain information that was key to their presentation, which was safety issues. And I requested to get some information. As the letter says, it's a complaint against Director Ed Riskin because of information that was requested and promised but not provided by various members of his staff. So I said on October 14, 2 weeks ago, Library Users Association attended a meeting of the MTA that was held to collect public comment on multiple proposed changes to San Francisco bus stops, parking zones, and the like. And then in Section A, I say, as the meeting proceeded, Library Users Association spoke with Will Tabahonda, an employee of SFMTA, and so on and so forth. And we gave him a post office box to respond to our request. At the time that I filed this, 2 weeks had gone by from the October 14th meeting. And I filed this at 4 o'clock on the afternoon of Friday, October 28th. The law requires a response within 10 days. So we waited 10 days, and then we waited altogether 14 days and got nothing from anybody. Section B, we also requested information from the 2 men leading the meeting. Before, during, and after the meeting, we provided our email address to them for this purpose. We have received nothing from them to date. C, we visited the office of the SFMTA later that day and spoke with SFMTA employee Sean Kennedy. At that time, we requested certain information and were promised it would be provided by email. As of today, we have received nothing from Mr. Kennedy. It appears that 4 employees have been unresponsive to our information requests. Consequently, it appears that the department head has not seen to it that employees are adequately informed, educated, instructed regarding the requirements under the Sunshine Ordinance to respond promptly to requests for information from the public. These 3 incidents represent multiple violations of Sunshine 6721 in a single day and suggest an unfortunate pattern of departmental non-responsiveness. You've already found from the documentation that Mr. Tabahonda responded by email to our request on November the 1st and again on November the 8th. At a minimum, those were very late responses. Thank you.
Thank you. Are there any persons or witnesses to provide any facts or evidence on behalf of the complainant? Seeing none? Are you on behalf of the complainant? Okay. Seeing none, the respondent has 5 minutes.
Good evening, task force members. Chair Wolf, my name is William Tabahonda. I work with the San Francisco Municipal Transportation Agency, and I am the project manager for the 7th and 8th Street Safety Project. So I met Mr. Warfield on the October 14th public hearing, and prior to my presentation at the public hearing, did receive a request for the documentation of the presentation, at which point Mr. Warfield wrote his P.O. box on a business card that I had. And I'd also like to note that we have several members of the staff that were there at the public hearing, so that would be Mike Hanrahan is here tonight, Tom Folks is here tonight, and also Dustin White is here tonight to help respond to any other questions you might have. But as the subsequent week, I uploaded the files to our project website. And the week subsequent after that, we started to receive immediate disclosure requests for information about the project from the Library Users Association, to which our agency responded to those requests. Subsequent to that, at that point, that we received the notice about the presentation material not being delivered to Mr. Warfield or the Libraries User Association's P.O. box, I then sent the information via email and post to the P.O. box. So I understand that the material was sent at November 1st to the P.O. box, and that subsequently I sent the material on November 8th, having not attached it to the original email. And I've apologized to Mr. Warfield for the delay in getting him the material, but I believe that we've been responsive and he has the information that was requested. Thank you.
Okay. Are there any persons or witnesses providing facts or evidence on behalf of the respondent?
Good evening, members of the committee. My name is Luis Montoya. I am the director of Livable Streets at the MTA. I want to say good evening to Frank, who I know from past work. Yes. I wanted to respond to a piece of Mr. Warfield's, or rather the Library Users Association's claim that there's a pattern of not being responsive, or that there's some sort of endemic issue at the MTA. I would just say that he's presented minimal evidence to that fact. He points to one instance, which we are fully acknowledging, that we were late on a response and that we did our best to comply with as soon as it was brought to our attention that we had, as Will said, had not been fully responsive in a timely manner, and we fully own that. But that there isn't a larger pattern of facts that Mr. Warfield's trying to point to as to drawing that the MTA is somehow negligent in a broader manner. That's all. Thank you.
Thank you. Are there any other persons or witnesses providing facts or evidence on behalf of the respondent?
My name's Tom Folks. I'm with the SFMTA. I'm one of the people who were invited to this meeting. I'm here to answer any questions that you might have regarding the request that was made. Basically, the way we handled the request was all the information that was asked for, we directed Mr. Warfield to Will Tapahonda to provide the information. I'm not sure what else to say in regards to this, but if you have any questions, I'm here to answer them.
Very good. Thank you. Or is there any others?
Good evening. Dustin White, also staff at the SFMTA. I wanted to point out that as part of the Library Users Association's testimony, they referenced an in-person meeting at our offices during which they spoke with Sean Kennedy. I was also present for a portion of that in-person, very lengthy discussion, and responded on behalf of Sean Kennedy with, I believe, all the information that Mr. Warfield requested during that conversation.
Thank you. Any others?
Good evening. My name is Mike Hanrahan. I work for the MTA. I work for the hearing section, and I conducted the public hearing that Mr. Warfield referenced. And his item was one of many that were before us that day. And I don't recall any specific request made of me regarding any information regarding the change in the bus route. Oftentimes people come up to me because I'm conducting the hearing thinking that I'm either a planner or an engineer. I'm not. I always refer them to the staff members that are there to answer their questions regarding their projects that they're interested in. Thank you.
Any others? Okay, seeing none. Members? Questions? Clarifications?
I have a question for you all.
Member testify.
Because I did read Mr. Warfield's letter, despite what he thought, and I also read other parts of the packet where a number of the individuals who have come before us, and it's also stated in the packet, I mean, I can lead you to a page on page 166, stated that they don't recall receiving the requests. And so I still have the question for the task force on verbal requests. How would you like the complaint committee to treat them? I know that the ordinance allows for them, but just as we're trying to weigh evidence, gather evidence, request additional evidence, what should we be looking for in support of that? Because it was very difficult for us to, try and substantiate. We had the letter that stated the requests happened. We had the response that said they don't recall any request occurring, besides the one that was admitted to Mr. Tabojanda. What do you recommend?
It's a hard question because, I mean, generally the ordinance is geared to be of service to the public first, and that any requests that are made of government is to be complied with, verbal, written,
Right.
or otherwise. So, the question becomes then if there is some conflict, or that on one side that something did happen and on the other side it didn't, and there's no evidence.
Or witnesses, other witnesses.
Or other witnesses, exactly. Then it does make it difficult at that point. I think that's why we're here, to at least try to figure that out. It's my hopes that the complaint committee can try to get that narrowed down so we don't have to do it here. It's not an admonishment. I'm just saying that it's
in this case, it's still that way.
It's okay. Gotcha.
So.
Okay. Well, I guess we can ask some questions about that, but I just want to ask one question first. Mr. Warfield, I am really quite confused by your request for this hearing as to who the respondent is, and then who the parties of the complaint are about, because it's directed at a specific person. Okay, for that person, in your own words, Director Ed Reskin of SFMTA failed to provide requested and promised information related to plan changes, Polk 9019 bus, and 3 stops near blah, blah, blah. It doesn't mention anybody else's name. It doesn't say SFMTA department. It doesn't mention a particular division. It doesn't mention, this particular hearing or anything like that. It just mentions the director. And so I'm a little confused as to how all these other people are involved when the actual directive of the complaint is to the department head.
If you're suggesting that the complaint should have been directed to the people specifically, such as Will Tabahonda, and so on and so forth, I can understand that. The reason, and I'm not sure I understand your question, it's been customary to name the department head or the department routinely as part of complaints, and even as the only person in charge of complaints. The department head is ultimately responsible. And so to go to 3 different persons and groups of persons and giving information for how to contact me, and then hearing ultimately, well, at the time I filed a complaint, hearing from nobody, that was pretty dismaying. I generally think that when staff makes a mistake, unless it's a particularly intentional thing, I'm reluctant to blame line employees when it seems to me likely, or certainly a good chance, that they don't know what the rules are in terms of responsiveness to requests. So I was entirely satisfied with Mr. Tabahonda's response when it finally came, except that it came so much later. Let me give you an example. Mr. White himself, as it's mentioned in the MTA's response, was very prompt on a completely different matter. He came to the library. There was a library-sponsored meeting.
But that's not my question.
Okay,
my
you're
question
asking why did I name Ed Riskin?
If Mr. Riskin were to show up here today himself, and not any of these other folks, because they're not party to the complaint. The complaint is specifically directed at Reskin. It doesn't include their names. It is quite more customary, especially for you, to include everybody that's involved plus the department head as being the Uber supervisor of those staff. So I'm a little confused because when I read this and when I listen to the playback, because I did twice also, I was like, so I don't understand why this complaint is against the director. He wasn't even involved in this. He wasn't asked. He wasn't requested of anything. So that's why I'm a little confused about this. And even in the first line of your complaint, you say this complaint is against Ed Reskin for failure to provide the information and promised but not provided by various members of his staff. Sure, maybe he's responsible. I get that. Okay, but was he ever contacted about this? You know, were these people under his direction for this particular item? I mean, that's usually when it rises to that occasion that the task force, at least in my experience, has brought it to the department head. Like when nobody shows up, or if the people that show up absolutely didn't know what was going on or didn't know how to do things, then I can see it. And usually we would rise to that occasion to include as the Uber supervisor and person responsible. But here you had direct contact with people that were actual custodians of information. You didn't direct your complaint to them directly. So I find it a little disconcerting, a little disjuncting and uncomfortable for me. Because I would just say, how are these people involved in any way, shape, or form? They're not party to the complaint. The only person that I can see that's party to the complaint is the director. So,
if you think that I should have filed a complaint that included the folks that I had the contact with, then I don't know. Then maybe it needs to be amended. If you think that it should have only been filed against the folks that were not responsive, I think that's a question.
I know you don't like when the task force puts the burden on the complainant, okay? But the introduction of the complaint makes it difficult. Okay, nobody is saying that whether somebody violated or something or not, and whether it's up to the complainant to prove it or not. That's not what the issue is for me here. The issue is you specified a particular person to be responsible for this, and he's not party to it.
The folks who I requested information from all work under the ultimate supervision of the director. And they are also, for the most part, routinely in contact with public and with providing information to the public and with responding to the public.
But they're the custodians. Those are the ones that you engaged directly.
Right.
So why didn't you engage? Why aren't they mentioned as part and parcel to the actual complaint? I mean, why weren't they included?
As a first time, why did I not say this is against, that I want a violation found against the individuals? Basically, because, number one, I think if there's management that hasn't made clear to folks, I don't want to nail individuals, line folks. But when the line folks, 3 in one day at different times, aren't responding in the basic way that's required, it seemed to me that it wasn't just one incident, but that with all 3, it seemed as though there was a lack of management, instruction, and direction, telling folks when you deal with the public and they ask you for something, you need to respond. And again, Dustin White, I was puzzled why the MTA even mentioned Dustin White. What I recalled, and I think they mentioned it in their response, was a completely different event, and his response was entirely satisfactory and, in fact, exemplary.
I know, but let's keep to the point.
Through the chair.
Yes.
We're getting off track. He named who he named. He's entitled to file the complaint how he wants. Let's just deal with the merits, with the complainant and the respondent that are named.
I appreciate that.
Thank you.
I appreciate that. But, this is not a first-timer. And it's, my concern is, Mr. Warfield, is that you file a lot of complaints here. You know how to file them. You do file them against specific individuals at any one time or another. So I'm a little concerned here. I'm willing to go ahead and have this hearing, but it's only going to be against Director Ed Reskin.
Who do you think should be named here?
It's not for us to say that.
I got no response for 2 weeks, which was more than the 10 days required. If you think I've made a mistake in who I've named, I'm willing to take that, but I don't think that the department should not have a complaint when they have not responded, and your own complaint committee already has found a violation in one of those folks.
It's my contention that they didn't consider who the complaint was actually against.
I can also say this.
So that's all I'm saying.
Through the chair, we're losing decorum here. This is the opportunity where members of the task force ask questions of him, and we're sort of letting him.
Please don't patronize me. I get it. Okay. So I just want to move ahead with the.
Can I just say?
No, we're just moving it.
Okay.
DC Acola, please. I'm running this meeting. Okay. I'm running this meeting. Okay.
I agree with your concern, Member Wolf, and that's what I was trying to articulate at the beginning. That I think that maybe it's not a notice concern to everyone here, but they weren't the people that were actually named in the complaint.
Okay. I just want to know that I sent a memo to Mr. Warfield and all the parties, including yourself, Member Tesfaye, explaining procedurally that I felt that this was not properly processed. So, Vice Chair.
Through the chair, I just want to thank the members of the MTA and all of them that showed up. Again, I'm hearing that they spent a lot of time with Mr. Warfield in person, answering questions. This is not new. We've heard this before in other cases where he gets a lot of time out of staff. And I find it a little disingenuous that he's coming back here. And that's just my reflection. But to the letter of the law and the complaint, I think we have a problem here.
Okay.
Is there a recommendation from any other members on how to deal with this verbal complaint and not having any either a eyewitness or some kind of someone to help us figure that out? In your experience, nothing? Okay.
I don't have any experience with verbal. I've never had a case before me.
So
we had one a few months ago.
Yeah, we had one.
Did we?
With Mr. Warfield.
Oh, okay.
And I think we kind of admonished it then, too.
Yeah.
All right. Member Canada.
So for the for the request that Mr. Warfield made during public comment. That would be in the video or the audio of the meeting.
For the actual
If it was during public comment, if there was a request made during public comment, that should be as part of the meeting. For other verbal requests where, one party says it was made and another party says they don't have a memory of a request being made.
Well, I think you have to ask the question of when Library Users Association spoke with any of these members. I mean, it says that there was a meeting that held public comment on a number of proposed changes, but in his complaint intake, Mr. Warfield says, as the meeting proceeded, Library Users Association spoke with Wilbur Tabahonda. Well, was that on the record in a microphone, or was that off to the side of the room or outside of the hearing hall? I think you have to qualify that first.
Would you like to ask me?
Yeah, Mr. Warfield.
No.
Please. Other than Mr. Tabahonda, at the meeting, did you make requests that were on the record?
I'm not sure. I was very concerned about the lack of materials. I don't know if I would have worded it specifically that I would like explanatory documents. I was puzzled that there wasn't even a mention of explanatory documents on the agenda. So I know that I spoke before the meeting and after the meeting with the two gentlemen running the meeting, and I certainly was concerned about explanatory documents during the meeting and at that item. With respect to the chair's question, it says under item A of my letter, as the meeting proceeded, Library Users Association spoke with Will Tabahonda and so on. In the hallway outside the meeting room, we discussed the plans, and Mr. Tabahonda promised to send us certain information. I'd also like to say that in response to Mr. Hyland, there isn't a question of how much time is irrelevant, but in fact, this was my first meeting there, and there was essentially very little time spent discussing anything, and there were specific requests that were made. Mr. Tabahonda replied to those requests, in fact, more than what he said. He not only sent the material that he presented at the meeting, but he also provided something that I asked for, which came up in discussion, and that was loading statistics for the numbers of people who are boarding and getting on and off. Here's the table, getting on and off the route. So he was fine. Everything he did was fine, except he evidently was unaware of the timing requirements. Again, I requested from the administrator, and I looked at regarding what did the complaint committee want, or what were any issues that they had, and there was not any statement about the question of who this complaint was directed towards. And the administrator said, look at the minutes. I looked at the minutes, and I also listened to the tape. There was no request from us to change or consider or modify who this was directed against. If that had come up at the complaint committee, we could have discussed it there. Again, it troubles me a great deal that I'm reporting something that happened where there was no response that was appropriate. Waited extra time to give them a chance. This was my first encounter with MTA in this fashion. And then eventually got something from one of the folks and never heard back from the others. You also heard from Mr. White that he was there for part of the conversation with Mr. Kennedy. Mr. Kennedy is not here. He's the one who was in charge and from whom I requested safety and accident information. As far as I'm concerned, if you want to find the only violation was the one that you have documented, which is the late response, that is a minimum that I think would be appropriate. Documented you have that the response from Mr. Tabahonda was longer than 2 weeks, longer than 10 days. But in terms of requests and in terms of time, the simple thing is I made straightforward requests, didn't get a response, and now I'm here trying to get some kind of a finding as well as response.
Member Hinsey, did you have a question?
Oh, no.
Okay. Any other questions, comments? Okay, let's move to rebuttal. The respondent has 3 minutes for rebuttal.
Yes, thank you. Once again, Luis Montoya, Director of Livable Streets at the SFMTA. I did just want to clarify some of the points that Library Users Association made, that Will did not willfully disregard the request. Will has acknowledged that he didn't remember. He was responding to multiple requests from Mr. Warfield. I don't think those are in the record. There was multiple exchanges with Mr. Warfield. He was never reminded of that verbal request. Not that it's Mr. Warfield's job to remind him, certainly. That's not what I'm not trying to excuse it, I'm just trying to explain it. As soon as he was brought to his attention that he wasn't compliant with that verbal request on the 14th, he responded, I think within like 1 or 2 business days. I think we were reminded on the 28th, which was a Friday, and Will responded on the 1st, which was a Tuesday. And so I think we were, really trying to comply with the spirit of the request as soon as information was told to us that we weren't in compliance. And I think, just adding that all the individuals that were listed came, except for Mr. Kennedy. Mr. White was here to represent Mr. Kennedy, and the response that was provided about the request to Mr. Kennedy came this evening. We spent an evening here with you all to try to get to the bottom of this, despite not being directly listed, as you pointed out, on the complaint. So we really are trying to do our best to share with you all the information that we have. So thank you.
Thank you. Complainant? 3 minutes? Nope, it's only one person for the rebuttal, I'm sorry. Go ahead.
Peter Warfield again. In the rebuttal, you just heard that we made multiple requests. In fact, we made no other requests from anybody at MTA between the time of the meeting and the time of our complaint. I wanted to be very quiet and just see how they would respond on a first-time contact basis, simply asking for basic information about the project. So there were no requests, multiple requests, or anything else. There was that day's requests from each of the parties. Mr. Kennedy did not show up. I'm glad the others showed up. I appreciate it. But the fact is that we made requests and there was no response within the required 10 days. And after 14 days, we filed a complaint. The complaint committee did not have a problem with who the complaint was said to be directed against. You have also, in this task force, found ways to add violations or add people to the violations, even discussing whether they had been notified. If you want to add the folks who responded, that's up to you. My idea was that for a first encounter, it was discouraging and worse that nobody responded. It seemed to me that rather than nail individuals who may not be aware of what the rules are, may not have learned it, may not have been told, aren't required to go to the annual Sunshine training as the director is. That's why I named the director. I named somebody at the agency who's accountable. And you yourself at the complaint committee have determined that there was a violation that's documented. The response from Mr. Tabahonda came November 1st, which is well after the 10 days, which would have been the 24th of October. If that's all you want to find as a violation, then that's up to you. I think you know me generally as somebody who it's probably not so difficult to, it's not unlikely that folks are going to get an information request, particularly when I'm brand new to the subject and scrambling to understand what's going on. In particular, I was concerned. I wrote an article about it. I sent the MTA board a letter the following month at which I said I was very concerned about safety issues and how they had researched those in terms of what was in the past as well as what was the expected safety issues from their proposed solution. And in fact, they ultimately decided not to reroute that bus for the moment. Thank you.
Thank you. Members, is there a motion?
Well,
Member
I mean,
Canada.
since Mr. Tabahonda did admit that he was late, whatever the reason of responding, I think that the recommendation from the Complaints Committee for a violation of 6721 is appropriate.
I'll second that.
Moved by Member Canada, second by Member Hinsey. Any discussion? Let's go to public comment.
David Pilpel, several things. First of all, the chair made reference to a memo that was sent out to various people. That's not in the packet. We can't review it. We'd love to see it. I might make comment on it. Secondly, the committee recommendation is also not in the packet, so the agenda makes reference to referral with recommendation to find violations, but the actual committee recommendation isn't in the packet. Can't see that. Don't know what the actual recommendation is. Third, the MTA has 5 staff people here who've been here since 4, so that's going on 20 hours of city time just to deal with the response tonight to Mr. Warfield's request. Moving on, I think Mr. Warfield is wrong in this case. Certainly, there is no violation by Ed Riskin. I think you've made that clear. I don't think you can find any violation there. If the only violation that's possible here is one of the staff people who may have been late or misunderstood or forgot a request, I think that's very minor league, and I think Mr. Warfield is making a much bigger deal out of this than is actually here. Mr. Warfield is very familiar with the ordinance. This is not his first time around. He certainly knows from attending many of these task force meetings that Ms. Celaya is the custodian of records and the person who handles sunshine requests over at MTA. Mr. Warfield certainly has a phone, a computer, access to a fax machine, all kinds of communication tools. He could very easily have directed a specific request to Ms. Celaya for whatever he wanted on the 19 Polk reroute or anything else at the MTA. I certainly make requests to Ms. Celaya, and several days later in my very mailbox arrives the documents I'm looking for. It works very well. Moving on, the staff people that are here have made clear that they attended to requests as quickly as they were made known to them. I think they have done nothing wrong. I certainly have taken issue with MTA many times in the past. I think that a lot of the decisions that they make and recommendations and proposals are rather boneheaded, for lack of a better term. But I think the staff in this case have done a fine job, and I don't think you can really find any meaningful violations against the folks that are here, and certainly not Mr. Riskin. So in summary, I don't think there's anything really here. I would recommend against the motion. I don't think you need to find a violation for the one individual for the short period of time. And in the future, I think Mr. Warfield should direct his request for MTA information to Ms. Celaya. And we should be done with this. This has taken far too long. There are other staff and other cases before you. Thanks.
Any other public comment?
Good evening, Michael Petrellis. I've been sick recently, and I held a protest over the weekend where I wore a face mask because I'm trying to recover. I really wish that I wasn't here at all, but I'm here tonight because my complaint follows this complaint. I've been here since 6 o'clock. I'm here to criticize Peter for contributing to my bad health. I'm here to criticize Peter for what I consider to be a wasteful, vexatious complaint. He knows how to play the game. He is not only taking up the time of all of you who are volunteers, he's also taking up the time of everyone else who has a complaint and wants our matter heard. I could not follow what Peter was talking about. All I can really say I've grasped is that he made some verbal communication that wasn't acted on with the city agency. I happen to have dealt with this city agency over the years, and I can tell you that in my requests, which are in writing, I don't have time to play games when I am making a request like this. The SFMTA has been really good about giving me calendars, emails, contracts. So many documents have come my way by putting it in writing to this agency. I do not get the sense that Peter has done this. I am really getting the sense that Peter just wants the attention that he gets by coming here, by tying up the city agency, by tying up your time at the committee level and here. And I have to say, even though this is not related to this complaint Peter has against the SFMTA, he is too often filing, it seems, the same minor complaint with the Library Commission, which is also taking up the time of volunteer commissioners and everyone else who has a complaint. It is now 8 o'clock, and I would like to be home taking care of myself. But I am going to wait because my complaints are very important to me that you have not heard, I believe. Okay? Lastly, I always thank you guys on this commission for being volunteers for democracy, and I would like to say that again, but I'd also like to ask you to start setting time limits for every item on your agenda. Please set a time limit, especially when it's a vexatious complaint from someone who knows better. Thank you.
Any other public comment? Seeing none. Call roll.
On the motion to find a violation of 67.21 in regards to the response provided by Mr.
Change the order. Change the order of the roll.
Call me first.
Yes,
Okay.
Mr. Tenjori. On that motion,
Did you finish reading it?
it's just find a violation of 67.21 against that one specific individual.
Okay.
Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
No.
Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
No.
Hyland, no. Member Baranetsky.
Aye.
Baranetsky, aye. Chair Wolf.
No.
Wolf, no. The motion fails.
Please call the next item.
Next on the agenda, item number 9, file number 16109, complaint filed by Mike Black against Animal Care and Control for allegedly violating Administrative Code, Section 67.21, 67.24, 67.26, and Government Code Sections 67.52E and 6253A by failing to respond to a request for public records in a timely and/or complete manner.
I can give a brief summary.
Let's do jurisdiction first. Motion for jurisdiction.
So moved.
Moved by Hinsey.
Second.
Second by Member Tesfa. Any discussion, public comment on jurisdiction? Seeing none, acclamation. Seeing no objections, item is approved by acclamation. Member Tesfa.
A brief summary of this item. The petitioner, Mr. Black, has been trying to get documents from the Animal Care and Control Department, specifically some either licenses or applications for dog licenses, as well as communications within the agency on dog leash rules and policies, laws, things like that. And he filed this complaint because when they did respond, the document was extremely redacted without explanation. I mean, that's basically it. Was that the document was extremely redacted without explanation, and but it appeared that all the facts were in order, and we thought that this item was ready to appear before the task force. The recommendation is on the agenda, I believe, but we'll let you hear the facts from Mr. Black.
Okay. Let's hear from the complainant. You have 5 minutes.
Mike Black again. The complaint I filed with the task force back in November actually consisted of 3 complaints and a lot of supporting material. And what I'd like to do now is just quickly go through those 3 issues. Forgive me for reading. Number 1, Animal Care and Control refused to provide me with a copy of a particular dog license application, not even a copy with the name redacted, which ACC claimed was exempt. In fact, ACC didn't even confirm the existence of the dog license until 3 months after I had requested it. As well as being untimely, this was a violation of Section 67.26, which mandates minimal withholding, and 67.24I, which exempts only information that is expressly and specifically exempt by statute. There is no express or specific statutory exemption for the name and address on a dog license application. ACC invokes Government Code Section 6254C's reference to privacy to justify its withholding of the name, but both the California Attorney General and Supreme Court have made it absolutely explicit that such information on any license application is not exempt under 6254C. There was never any legal basis for any withholding or any redacting, and ACC should have immediately provided me the unredacted dog license and application 7 months ago when I first asked for it, not waited until just this past week to send me a tag record with the name still blacked out. Number 2, my request for ACC's written communications related to the dog leash law and its enforcement has never seen a complete response. ACC refused to provide any emails until after 4 months of my dogged insistence for them, including appeals to other city officials in the face of ACC's repeated false declarations that all responsive records had been produced. Worse, just hours before the submission deadline for this hearing, ACC at last sent me batches of off-leash dog incidents as reported in ACC internal communications. Records specifically sought in my original February 1st, 2016 request, which I was told months ago didn't exist. The lesson here seems to be, hound us for a year and drag us to public hearings, and then maybe we'll start to take your request seriously. After its many outrageous acts of bad faith, when ACC claims certain records don't exist, it's impossible to know what's poor record keeping and what's simply untrue. Even ACC had to concede in its December 8th response to this complaint that there were still missing emails, and the new custodian of records promised this task force that, quote, I will assure that these searches are properly and immediately conducted so that Mr. Black receives the missing emails. Yet almost 2 months later, I still haven't received a single additional email. More examples. Emailed complaints to ACC seem to have no record of any response whatsoever, while one violation record states, see attached email, but has no attached email. And where are ACC's consultations with the city attorney regarding my requests or communications related to ACC's decision not to enforce the city's leash law? I provided the task force an email history that shows it's been one long battle getting records from ACC. And that obstructionism shouldn't be tolerated, and no agency should be allowed recourse to strictly optional exemptions when it has contemptuously abused the statutes as ACC has in this case. To put it bluntly, ACC cannot be trusted. The staff has proven itself incapable of culling its own files for the requested records. Accordingly, ACC should be compelled to produce copies of all of its written communications, and I do mean all, from January 1st, 2014 to August 11th, 2016, as I requested back in August. Finally, I expressly complained about that contempt ACC has shown for the law, a somewhat general complaint because the offense has been so broad. Today marks exactly 1 year since I first submitted a public records request to ACC, which then proceeded to violate the spirit and the letter of seemingly every sunshine law, from ignoring mandated deadlines to displaying an exasperating uncooperativeness. Before I discovered the immediate disclosure request procedure, I had to seek the city administrator's or supervisor of records intervention. But I'm not sure it's fair to hold ACC or any employee there solely responsible for the way my requests were handled. The city attorney's office was copied in on ACC's email exchanges with me from early on, and the supervisor of records fully supported ACC's illegal withholding of the dog license. The city attorney has served this agency as poorly as it served me. There may be no remedy at this point for all the bad faith conduct other than the sanctions I mentioned with regard to written communications and blocking ACC's resort to statutory exemptions.
Please wrap it up. Right, finished? Okay, great. Thank you.
Thank you.
Are there any persons or witnesses to provide any additional facts or evidence on behalf of the complainant petition? Seeing none, respondent? You have 5 minutes.
My name is Diana Christensen. I am the new custodian of records for animal care and control. This is one of those complaints that goes back from a request that was in February 1st, 2016. It involves primarily a custodian of records who is no longer with the city and who is retired. And it involves thousands of documents. We have provided thousands of documents. First, I just want to say, just because I don't think we're here very often, this is a very small department. It's got 60 full-time equivalent employees, about 45 actually filling those spots. It's open 7 days a week and covers an 18-hour-a-day span. So if you do the math, you'll see it's not very many people. We take care of 250 to 300 animals at any given day. We have 10,000 animals that go through the ACC in a year's time. And we have about 12 animal control officers who patrol the city. And the issue here, I think, for Mr. Black is that he would like to see us enforce the leash law as though we're the police department. We're not. We don't have the kind of staffing that we would. And in fact, I came from Human Services, and it was night and day, the difference between the resources available to even manage the sunshine requests, night and day from Human Services to ACC, because there's 2 clerical people at ACC doing a full broad range of everything, and they don't do sunshine. So to give you an idea, nobody's just focused on getting these records. When they did get the records, there was an approach to it by the then custodian who was trying to figure out what Mr. Black wanted and trying to give him what he wanted. And what she neglected to do was to do the paperwork of saying, I need more time, I'm consulting with the city attorney's office, or I'm consulting with a different department. She didn't manage that time well, and so she violated the exactness of the time frames. But she went out and had our database programmed with our IT people so that it would get reports that she thought would be responsive to what he was trying to get to, and it wasn't what he wanted. He clearly wanted, from his point of view, the things that he wanted, and she didn't get them to him in a timely way. Ultimately, she did. Ultimately, she sent emails from 2014, 2015, 2016. He didn't get them, and it wasn't understood. And he said in one of his letters to you that he understood, and it was probably nobody's fault that we didn't understand. He didn't get them. We didn't get a postal response from the email servers back saying that they hadn't been delivered. I personally have went through her email since she left, and I didn't find anything of that nature to say that. As for the license, I have been assured by the city attorney's office that the law degree that Mr. Black is purporting not to have, or his experience, is not correct, that we can assert on a license that there are privacy concerns. When somebody goes for a dog license, they're not expecting to have the exposure of their name and their address put out for public record. That's a legal issue that's beyond my pay grade, and I encourage that you would ask the city attorneys for their response on that. But I've been assured today, even, and all along, that that's the case. So we didn't have those. As to Mr. Black claims that he didn't get several of the emails from us that he had sent to us, and first of all, he already had them. Clearly he did. That's what he sent to you to say, why didn't they send me these? We didn't send them, and I think for a number of reasons. One is because in Microsoft Office, there's a 250 item search limit, and we hit it. And that's on the ones at ACC. I'm not sure how it works elsewhere, but we hit it, and we weren't able to get past it as a staff. And I think with a staff that often doesn't use that computer system, I think it was, we got mixed results from people who searched their data systems. So there were potentially some missed.
Okay, thank you. Okay, members? Oh, I'm sorry. Are there any persons on behalf of, or witnesses on behalf of the respondent providing any additional facts or evidence? Seeing none, members? Vice Chair Hyland.
Mr. Black, if you could approach. So from what I've heard, it looks like Ms. Christensen is trying to play catch up and be responsive to the documents that you've requested. What is still outstanding in your mind?
An unredacted dog license, an application.
I'm sorry,
unredacted dog license and application. If I may just point out that the city attorney's office does seem culpable on this issue. That
I'm sorry, I'm going to interrupt you there.
Oh,
so
okay.
I just want specific answers to my questions. You're looking for one unredacted dog license, several? What exactly are you after still?
It was for a particular address. I was told there was only one licensed dog at that address. So I assume it's one, I think one document. I'm not exactly sure. I know that there's this dog application that gets filled out in order to get a dog license. If there's some other paperwork in addition to that, my original request on June 23rd was for everything related to any dog or dog owners at a particular address. I never received anything in response to that request.
Okay. So that's one piece of information. Anything else?
There are emails. First of all, I would point out the emails again that the custodian of records, Ms. Christensen, said in her response to my complaint that she would look for and produce. She conceded that there were missing emails. And I haven't received an additional email since that response that was submitted to the task force. There are...
Specifically, what emails are you referring to?
Well, she says in her response letter, I produced certain letters that she should have produced to me. I said, here are these letters that exist. And so she responded that, well, yes, there are these letters that seem to be missing, and it's because certain key employees' sent boxes were not checked. And so she said, that's when she said, quote, I will make sure that there are searches that are properly and immediately conducted so that Mr. Black receives the missing emails.
Okay, so to summarize, there's one dog license issue fully or completely unredacted, and then several emails at question. That's
right. And well, I was actually asking for all written communications related to the dog leash law and its enforcement.
Okay.
And like just this.
And the emails pertain to that topic.
Right.
Got it. Okay. Those are two things that we're trying to get to the bottom of. Okay. That's all.
Okay.
Thank you.
So, can I just point out quickly that that ACC did produce more responsive documents last week, as I noted, but apparently there's a section of time that Ms. Christensen said she was still looking for other records from that period of time.
Right. So she noticed that, said she'd give it to you, go keep looking, give it to you in batches. That's how I understood that.
Well, she just said she would produce them, but then she promised 2 months ago that she was going to give me more emails too. So I don't know.
Okay. Yeah. In many cases with voluminous requests like this, Mr. Black, city departments will try and give it to you in batches. So whether it's a month, 2 months, that's something we can get to the bottom of.
In addition, under an IDR, there's on a rolling basis. That's essentially
right. Technically, the first request a year ago was not an IDR, just so that's clear. It was a public records request under the CPRA. But
okay.
I understand all of that, but I also understand that the laws require that there's supposed to be a certain level of contact maintained with the person who's asking for the records. You're supposed to be helpful. You're supposed to make it clear when you don't understand what they're asking for. Make suggestions. Well, maybe, is this what you mean? Is that what you mean? After my first request, I didn't receive any response of any kind for a month. And that's what it's been like for the past year. Yeah. Only when I discovered this immediate disclosure request, this IDR procedure, where they have to respond within 24 hours, did I start to get kind of prompt responses. And they would say, yes, this is going to take a while, we're asking for an extension. But I had got nothing like that for 9 months.
Thank you.
Okay, thank you.
Any other questions? Member Hinsey, sorry.
That's okay. Ms. Christensen told you that
Mr. Black.
She gave you her justification for why she can't release an unredacted dog license. So do you have a case for why the AAC should be able to release an unredacted dog license?
Well, I've gone through this at great length in the documents that were submitted, but the California Attorney General's summary of the Public Records Act explicitly says of this section that they're relying on, information provided by license applicants is not covered by this section, and yet they keep trying to use it.
Let me just interject here for a second. It's really incumbent upon the respondent to prove that they were correct in why they withheld information or redacted information. It's really not up to the complainant to make that case on behalf of himself. He's not on here as the defense per se. So and that actually was going to be my question to the respondent, was really more about where they got the idea about redaction and all that. And if it comes down to advice from the city attorney, there are kind of some passages in the ordinance about that. So I think really we need to focus on the respondent is the one that has to prove essentially why they did what they did, essentially. Okay? So I'd like to keep our focus in that direction.
Through the chair.
Hey, hold on a second. Member Hinsey, is there anything else that you...
None at this time.
Okay, great. Vice Chair
Ms. Christensen, you can approach. And while she approaches, I know we had a hearing, pretty famous one a couple of years ago, about applications for boat licenses. I'm not sure, this might have been before your time, but and perhaps DCA Cole can help me out here, but it was the assumption of, if you fill out an application, whether it be for a dog license or a boat license or a berth, whatever it was, that it will become public knowledge. So I think some of this revolves around that, but perhaps we can hear from Ms. Christensen as to her justification for redacting parts of.
We went to the city attorney's office and got an opinion that we weren't required to provide them when we got the initial request, and it had been our policy not to because of privacy reasons, and so we didn't. I went back twice and had conversations with the city attorneys, with our city attorney about that. There are documents within the materials that you have that have his explanation for it laid out.
Okay, so I mean, that's client, department privilege, but basically you're saying
it was provided to you.
Yeah, on the advice of the city
On
attorney.
the advice of city attorney. I also, on the email issue, I have been trying to get the emails that he didn't get. I have had technical problems trying to get them from our system with the ones that are older.
And is it true to say that you're the only person that's doing this?
Yes.
Yes.
It's also true we've given him 624 pages of emails. It's also true that we've given him about 1,900 activity reports for our ACOs, the animal control officers. We've given him hundreds of other documents on top of it, trying to be responsive with this. They haven't been timely. And they started getting more formalized in what he was talking about because I was hired there, and I started talking to the then custodian saying, you need to send a letter and say that we got this, say that we're going to be longer, say we need more time and the justification for it. She just didn't know.
And as well as being custodian, you're deputy director of the center, is that
Yes.
right? Okay. And how long do you think it'll take you to, on a rolling basis, get the rest of those emails to Mr. Black?
The problem that I'm having with the emails is, frankly, I don't know what he's got and what he doesn't at this point, because it means that I have to go through the 624 that we've given him and compare them to whatever I pull out of the system to see whether they've gone. Assuming that I'm going to get the help that I need to actually pull them, and I think I am. I'm closer. I should be able to do it within the next few weeks.
Thank you. DCA Cola, any input on whether a dog license application would be a public?
Well, they do a balancing test to determine whether or not the public interest of disclosing a record outweighs the privacy concerns. There's case law out there either way. It really depends. It depends on the circumstances, but something that discloses a person's name and their address, that's iffy as far as case law goes. I think in some of the instances that the complainant had cited in here, there was one case regarding firearm license applications. I think the court ruled that it would provide their names, but it didn't say anything in the opinion whether or not it provided their addresses. Mm-hmm. So, that sort of suggests that at a bare minimum, he should have been provided something with partial redactions. I don't know if or when he got that or how late it was after the request.
All right.
Yeah.
Ms. Christensen, if you could approach again. The dog licenses that you did provide, or what was?
There's one license in particular that he was looking for.
Okay.
It was supposed to have been sent. He asked for it, I believe, in June, July. There was a response to it saying we were going to redact it. There was no attachment. I sat with the other custodian of records in September, shortly after I got to ACC, watched her redact the name from it, and it didn't end up attached to the email. And I recognized that only when I was preparing for this hearing. So a week ago, I sent him a redacted copy of what we had. I don't believe that there are other records related to that license that we've retained.
Okay, and no other license or documents pertinent to that address?
No.
Okay, so you believe you fulfilled, per the city attorney's advice, that portion. So all we're talking
Yes.
about is the 2 weeks' worth, hopefully, of rolling emails that you'll get to the bottom of.
That's right.
Okay, thank you.
Thanks.
Can I just make...
No.
Oh.
You'll have a chance during rebuttal
Oh,
to make
okay.
any additional comments. Any other questions, members? Okay, let's move to rebuttals. Ms. Christensen, you go first. Ms. Christensen, you go first. 3 minutes for any rebuttals.
I think we've provided thousands of records in response to the February 2016 request. I don't think they were done perfectly in the timing way that they should have been, or sometimes even in the format. But I believe that the vast majority of records that exist got there as intended, and there were thousands of them. I don't think that it was any malicious or contemptuous feeling by staff about Sunshine. I think that it's a busy center. People are focused on the life and death of animals and not particularly on bureaucratic paperwork. And that's the bottom line. I think the people who are there have goodwill in trying to do what's required. And I think in regard to Sunshine, I think the existing staff, when I got there, just didn't know. I think we know now. I think that I've been around this roadshow with you a little bit, and I think that it will change in the future. Thanks.
Thank you. Mr. Black, you have 3 minutes, rebuttal.
Well, the first thing I wanted to address was this, I think, a misconception about or misstatement of the law with regarding to weighing the public interest in withholding or disclosing something, because that's a complete violation of the Sunshine Ordinance. It's 6724I, which specifically forbids anybody to try to weigh the public interest in withholding documents. And it also, in G, explicitly prohibits the use of Government Code Section 6255, which is the state code which invokes weighing public interest. So the Sunshine Ordinance is much broader, and it says you cannot resort to this thing of trying to weigh the public interest. And again, the state standard is just so clear. CBSV Block is the case that everyone relies on that says that this statute does not exempt information on a license application. And again, the Sunshine Statute demands that there has to be a specific and express statutory exemption for something, and there is nothing like that for dog license application. There was something else that's going on in my head, so I think that's going to have to be it.
Thank you. Mr. Black, just a quick question for, are there any documents that you still haven't received?
Well, as I said in my statement, I mean, when someone tells me something doesn't exist, and I've had this history with them, and they say stuff doesn't exist and it shows up.
Just plainly, are there any documents that you still want that you have not received?
Communications regarding ACC's decision not to enforce the city's leash law.
Okay. Thank you. All right, members. Motion.
I'd like to make a motion.
Member testify.
Yes, for violation of Section 67.21D, 67.24I, and 67.26. I would also like to include, well, I guess we should, sending it to another committee for follow-up. That should be after the motion or with the motion?
You can put it in the motion if you like.
And just a follow-up with compliance to make sure that Mr. Black receives the documents that he requested.
I would try to specify what that is, because it's
Okay.
kind of open-ended,
Sure.
and this is such a voluminous amount of information over a very long period of time. I would just try to narrow it down.
Okay. So that would include the rest of the emails that they are currently producing on the enforcement of the dog leash ordinance, and that would also include an unredacted version of the license that was requested for the 17th Street location.
Wait, is there a second?
Good.
Okay, second by Member Baranetsky. Okay, Vice Chair Hyland.
I disagree with the second part about the unredacted license, and I would vote against that motion as it stands. If you want to separate it, that might.
I don't think you need approval to divide the question. You can ask for the question to be divided.
Oh, I see. Okay.
Just say, I want to divide the question, say which part you want divided, and we'll...
Well, actually, we're talking, actually, I take that back. That's not the motion. And again, I think that should come after we vote on the motion, because we're confusing that as part of the motion
That's
now.
part of the motion because...
I think that would be advice from the chair to the committee on how to...
It's if somebody wants to make a motion, they can make that, and it be the order of the body to do it, which has a lot more power than just the chair's recommendation to do that.
Okay. So I would move to divide that last piece.
Okay, so the redacted
I believe, is that 6724I?
67.26.
67.26 regarding redaction.
Yes, regarding, holding redacting kept to a minimum.
Okay, thank you.
Okay. So moved by Member Tesfaye, second by Member Baranetsky. This would be for...
Sorry, going back, I think it would also be 67.24.
Yeah, I got that.
Oh, yeah, okay, that's what we have.
Yeah, for violations 6721D, 6724I, 6724, right?
6721D, 6724I, and 6726.
Oh, 6726, got it. Okay, great. And this will be sent to compliance amendments for the rest of the email communications regarding enforcement of the dog leash law.
Yes, and then we'll take up the second section.
Second in a moment. Okay. Public comment.
David Pilpel, boy, it's getting late. Several things. There was a case before the task force about 10 years ago. I'm now remembering it was either Brett Plater or the Wild Equity Institute that was looking for something about dogs and dog licenses, and the way their records were organized at the time, it took them hundreds of hours to go through and pull physical files and separate and copy and redact, and it was a big deal thing, but they provided the documents on a rolling basis. It sounds like some of their record keeping still needs some improvement, but now that Diana Christensen is over there, I have great confidence that things are going to get better, because Diana understands both Sunshine and has been here a number of times and gets confidentiality because she handled investigations at HSA and is a good person, and she will make things better over there. Right? Right? Yes. Good. Meanwhile, I am pretty impressed with Mr. Black and his legal reasoning, even though he's not a lawyer, or so he claims. But his arguments were very good and well stated. Although there's been a fair amount of discussion about the CBS v. Block case, I actually don't think that's the one that's most on point. I think it's the San Jose Airport case. And unfortunately, I'm getting old and I don't remember how that was resolved, but it was another issue about it was actually about complaints being filed about airport noise and whether the contact information for the complainants needed to be disclosed. This is not, and I want to emphasize, not a 6255 balancing of the public interest in disclosure versus the public interest in non-disclosure. This is a privacy balancing of the reasonable expectation of privacy that the individual holds versus any public interest in disclosure. And that's different. That's not barred by the ordinance. That is a state, actually more of a state constitution privacy thing that's layered on top of this. So I don't think that the 67.24I violation is well placed. I think that I would separate that out, and I would vote no on that. I think that there is probably a violation as to 21 or 21D or probably 21D or somewhere around there about timeliness, but it sounds like the department is making efforts to provide what they can, and there's been good faith and better communications, and it sounds like Mr. Black's going to get most of what he wants. He probably isn't going to get the unredacted license application, so let's just be clear on that expectation, unless you have questions. Thanks.
Thank you. Thank you. Any other public comment? No, because you're party. No, because he's party to the, this is public comment.
Don't worry, anything he said is not what we necessarily will do. It's just everyone can speak. It's okay. You can. Are you the public?
Yeah, but I don't know the case well enough.
All right, any other public comment? Seeing none?
She could talk. Yeah.
Okay, let's go for a vote.
Wait, reread it.
I believe
was
that
67.
we'll be having two separate votes. One is regarding 67.21D, will be the first item. The second one will be...
No, it was 6721D, 6724I, and 6726.
Yes, but I'm trying to separate which one's going to have a separate vote.
Wait.
I'm sorry, 6726 was separated
Do
out.
these in numerical order, because that's how they show up here.
67.26 will
Yeah,
be...
21D and 24I is the first vote, and then 26 is the second vote.
Yes.
Wait, too much stimulation here. Can you just give me the
The
three?
first motion is regarding 67.21D
Yeah.
and 67.24I.
And
just those
sending
two.
it to compliance and amendments for the rest of the emails on enforcement of the dog leash law.
Right, and the second part.
Well, wait, let's do the first one first.
Wait, so it's 21D, the custodian thing, and then 24I, which in one's, which is the EFG. I don't know about either of these. Okay, go ahead.
On that motion, Member Kanata.
Aye.
Kanata, aye. Member Fisher.
No.
Fisher, no. Member Hinsey.
Aye.
Hinsey, aye. Vice Chair Hyland.
Pass.
Member Barnetsky.
Aye.
Barnetsky, aye. Member Tesfa.
Aye.
Tesfa, aye. Chair Wolf.
I'm last.
Vice Chair Hyland.
Aye.
Hyland, aye. Chair Wolf.
You were the deciding.
Wolf, aye.
man.
No.
The motion passes.
You were the decider.
I'm okay with that part.
Now we have to
Regarding-
pick up the second part.
Okay. now-
Regarding violation of 67.26.
6.
Okay, is there any, you want to divide the question, so is there any public comment on 6726?
I think we've already taken it.
Sorry?
I think we already took it.
Yeah.
No, not on the division.
Okay.
We only took it on the first. First is a completely separate motion.
Okay.
Okay, seeing no public comment. Any other discussion, members?
Can you just
Vice Chair.
explain maybe what this vote is on exactly?
You divided it.
Right. So this is regarding the redacted dog license issue. That's what we're voting on. Okay.
All right, so this is to find the division was to find a violation of 6726. So if you vote yes, that means you agree there is a violation. If you vote no, that means you do not agree there is a violation. Member Tesfaye.
Before we vote, can I just give an explanation as to why I made this motion?
Sure.
I mean, besides the portion of the Public Records Act that Mr. Black cited for saying that licenses would be disclosed, I was looking at some other cities that have similar ordinances. Their websites are more extensive, for example, in LA County, where they do explain to people about the sharing of personally identifiable information with third parties. And there is, a warning that personally identifiable information in accordance with the disclosure requirements of the California Public Records Act or other legal requirements may require us to disclose such information. So I think that it's unfortunate that our website has not given that information to people, and so they might have they may think that they have a reasonable assumption that their license would be kept private. And I think it's more of a problem on the city not giving. I think it's the city's fault in the situation for not having the website show that, when you fill out this license application, it's a public record. That being said, I don't know if it's fair to hold it against Mr. Black.
And if I could follow up to that.
Go ahead.
So my objection to this is I think, yes, there's a certain degree of expectation when you fill out a dog license and that information is public. Should it be available to a immediate neighbor who's trying to find out your name and other information because you fill that out for a dog license? I don't think so. And I think the city attorney has already advised this department that it feels the same way. And I think, even though it might be the spirit of the letter of the law, I think the spirit is there is some privacy here. And I think they would, I think the city attorney has ruled correctly in this case. And that's why I would oppose this.
Okay, thank you.
Can I make a comment?
No. Sorry.
Okay, well, we did hear the section of the Public Records Act, and these other websites immediately put as an initial matter, please be advised that animal control is subject to statutes relating to public records of the state of California. And I don't think that it's fair for us to, just because our agency didn't put that on our website doesn't mean that it's not true. Sure. Just because people, when they fill out the license, don't know that the Public Records Act applies doesn't mean that it doesn't apply. So just keep that in mind. No more from me.
Okay, that's it. Call roll.
On that motion.
Wait, the motion was aye. There was something about if you vote yes, it's a no, or no, it's can
So
you?
this is defined in violation of 6726.
Mm-hmm.
If you agree that there's a violation, vote yes. If you do not agree that there's a violation, vote no.
Oh, okay. It's the usual.
Yes. Just wanted to be clear because of why it was divided.
And the violation is that animal care control redacted. If you feel they should have been able to redact, then you vote no. Did I summarize that correctly?
Right.
Okay, because it is confusing.
On that motion, Member Fisher.
Hold on. We just now got some
I just
confusion.
heard two different things.
Right.
My understanding is if you vote yes on the motion, you're saying that animal control should have provided an unredacted information, and compliance will ask them to do so.
Yes.
Correct.
Well summarized.
Are we ready?
Yes.
On that
Please call
motion,
roll.
Member Fisher.
No.
Fisher, no. Member Hinsey.
No.
Hinsey, no. Vice Chair Hyland.
No.
Hyland, no. Member Barnetsky.
Aye.
Barnetsky, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Chair Wolf.
Aye.
Wolf, aye. The motion fails.
Okay. Next item.
Do you want to explain to Mr. Black what happened? Just so he understands. No,
I don't think so.
Never. Okay.
Let's move on. So we're running out of time.
Next on the agenda, item number 10. File number 16091, complaint filed by Michael Trellis against Director Leanne Pellin and Commissioner Paul Rene, Peter Keenan, and Quentin Kopp for allegedly violating Administrative Code Section 67.15 and 67.21 by not allowing opportunity for members of the public to directly address a policy body on items of interest to the public that are within the policy body's jurisdiction, abridging or prohibiting public criticism of the policy, procedures, programs, or services of the city, and by failing to respond to a request for public records in a timely and or complete manner. I'd just like to let the task force know that this complaint was originally against additional departments, but the complainant withdrew his complaints against the sheriff and the city attorney.
Okay. Very good. Okay.
This one was from the Compliance and Amendments Committee.
Member Kanata?
Okay, so The complainant said that at the September 26, 2016 Ethics Commission meeting, his public comment was not allowed due to the fact that he was interrupted by the commissioners because he was holding up a sign, and the commissioners started questioning him about the sign, and Mr. Petrellis contends that his time was not allowed to do public comment. As the clerk said, the original complaint was also against the sheriff's department and the city attorney, and those were withdrawn at the compliance meeting.
Okay, great.
And we did provide a recommendation, but we'll leave that.
Let's do jurisdiction. Let's have a motion.
Motion to find jurisdiction.
Second.
Moved by Hensy, second by Kanata. Any public comment on jurisdiction? Seeing none, can we take this by acclamation? Seeing no objection, item is approved. Mr. Petrellis.
Good evening, Michael Petrellis. Would it be best to show the video from the meeting?
It's your time.
I'd like to show the video from the meeting in question so you can see what transpired.
It's your 5 minutes.
We saw it at the committee meeting.
Victor,
give me a moment.
Roll tape.
He has to click the
Chair
link.
Wolf, can
He has to
you-
click
or-
the link. He's going to click the link.
What do you
I
need?
don't think we should take away Mr. Petrellis' time while Victor's setting this up.
I'm sure Victor is already.
I think we should take away all of this time while we set it up.
Trying to, you know, trying to be fair.
I was trying to be funny.
We're here for the people.
This is the most infinite body.
Oh, look who's there.
Chair Wolf, would you like me to, am I timing the
Stop.
video? Or are we?
How long is this video clip?
It's probably going to exceed 3 minutes.
3 minutes of them interrupting me.
Okay, but you'll finish your testimony within the next 2 minutes?
Yes.
Okay, so yeah, no problem. It's all part of it. This is his presentation in his 5 minutes.
This is Ray Hartz. I'm Director of San Francisco Open Government.
Thank you. Thank you. Good evening. My name is Michael Petrellis, and I'm here to address a matter I brought to your attention previously, and it has to do with a complaint I filed on February 25th of this year, 7 months ago. It was a complaint against the mayor because of...
Campaign signs to be displayed?
I don't think we should.
Oh, I agree. Put your campaign sign down. Campaign outside this hearing room. This hearing room is not a format.
Please stop the clock. I want my 30 seconds returned to me that you've taken up by interrupting me. And if you'd like to discuss signs in the meeting, I would like to see in writing the prohibition that prevents me from holding this sign. I want to see it in writing. Why you are telling me to put a sign down because I feel you are infringing upon my First Amendment rights. Can you produce in writing the prohibition that you say is the reason why I have to put my sign down? Yay or nay, can you produce it in writing?
Chair of the commission, I can make that ruling and ask you to put it down. Where's that in writing? And if you...
Where's that in writing?
If you aren't willing to put it down, then you can just step back. This room is not for political...
Why are you trying to infringe upon my First Amendment rights without producing in writing what you say are these rules?
Through the chair to the city attorney, is it legally allowable for a candidate for office to use his campaign material when testifying before the commission with a television audience of which he certainly has knowledge?
Off the top of my head, I'm not sure. I mean, it does seem like campaigning is not within the scope of the Ethics Commission's jurisdiction, and so I think
I suppose it's within our scope also to offer an opinion under the First Amendment on the merits or demerits of his candidacy. Mr. Chairman, I would like a written opinion. It ought to be short on this kind of campaign advertising in a
and I would like to point out, regardless of what my sign says, I want to see it in writing.
You, sir.
You have interrupted my public comment, sir, and I will not be cowed by this. I am holding a sign regardless of what it says. You claim you have a
I'd like to stop, but I think you get a sense. I think you get a good sense of what was going on. I am saying that regardless of a sign, as long as it's not bigger than 11 by 17, you're able to hold up a sign because of the First Amendment. Regardless of these three legal eagles, one, an ex-judge, trying to shut me down, they were violating the law and interrupting my public comment. I believe the law says you are entitled to your public comment, and if commissioners would like to question you about it, they wait until the end of your comments. What these guys did was a direct violation of allowing me uninterrupted public comment. That's the basis of my complaint.
Thank you. Are there any persons or witnesses to provide facts or evidence on behalf of the complainant? Seeing none, respondent, you have 5 minutes.
Hi, I'm Jessica Bloom. I'm Deputy Director of the Ethics Commission. I submitted a written response to Mr. Petrellis' comment that I think lays out the status of the law fairly well. If you have any questions about that, I'm happy to answer them with my 5 minutes, but in the interest of the late hour, I'll just leave most of my comments in writing. I'd add that I checked in with the City Attorney's Office again today, and though I don't think it's this task force's jurisdiction to determine whether or not signs can be held up at public meetings, I do feel like you would like to be informed, and he said it's still in draft form and not approved yet, so he can't release it. So I think everybody's frustrated by that, but hopefully that this incident will result in a comprehensive policy that regarding signage that applies to all Board of Supervisors and commission meetings. The thing that I would add is that there's a declaration from Catherine Argumido, who pushed the button, this timekeeper clock for Mr. Petrellis' comment, and she paused it every time there was a back and forth exchange with the commissioners. So Mr. Petrellis got his 3 full minutes. I think he got like 3 or 4 extra seconds over the 3 minutes. So the actual letter of the law was not violated.
Are there any persons or witnesses on behalf of the respondent provide any additional facts or evidence? Seeing none, Vice Chair Howard.
Mr. Petrellis, if you could approach. So I think I heard that despite the interruptions, and if you showed us the rest of the video, that they let you carry on and you got your full 3 minutes in. Is that what I'm hearing?
Yes.
Okay. But you're objecting on principle that you should not have been interrupted. Is that the merit? Is that
correct? And in the following complaint, you'll have to deal with the matter of at the next meeting they promulgated a new policy.
Yeah, well, let's stick to this case first.
A new policy just related to interruptions. They called for no interruptions, and I'm just trying to point out they were interrupting me.
So they interrupted you, they reset the clock, and you got your full 3 minutes public comment?
Correct.
Okay. Thank you.
What's the bio?
Anybody else? Any other questions? Move to rebuttals. Okay, the respondent has 3 minutes for rebuttal.
No rebuttal.
Complainant? Petitioner?
I would just like to say that Jessica has been terrific throughout this process, and unfortunately, she has to do the battle for what these 3 legal eagles were doing at that meeting, and I just want to give her credit in public for doing her job very well.
Okay, members? So, sorry?
I'm just trying, never mind, go on.
Member
Found it.
Canal.
I was just going to say that the Compliance and Amendments Committee did not find a violation on 6715 because of the fact that Mr. Petrillos did get his
He
entire
got it
3 minutes.
He had to fight for it, but he got it.
I'd like to make a motion. Find no violation of the section 6715.
To find or not to find?
Not to find.
Okay. Moved by Member Tesfaye.
Second.
Second by Member Hinsey. Any further discussion? Public comment? Seeing no public comment. Oh, public comment.
Can't get rid of me that easily. David Pilpel.
Wasn't trying.
I appreciate that. I believe in the original complaint, Mr. Petrillos said that I was at the meeting wearing a campaign T-shirt. I don't see in the video. I don't see the video anymore. I did not see myself in the video. I may well have been. I'm sure I was wearing some shirt. I don't know what it said. Nevertheless, on the particular facts, I think it's clear that Mr. Petrillos was interrupted, but was given his time and was able to complete his statement. I'm not opining right this moment on whether or not one can hold up signs and campaign in connection with public comment. I'm choosing not to, but I think on the particular facts there was no violation, and so I support the motion before you. Thanks.
Okay, seeing no other members of the public, let's go for a vote.
On the motion, Member Hinsey.
Wasn't expecting to be first. Aye.
So it's
Hinsey,
no
aye.
violation. Yeah, we never used
The
to
motion
do
is to
this.
find that.
Okay, got
there-
it. Yeah, I got it.
That. Vice Chair Hyland.
Aye.
Hyland, aye. Member Barnetsky.
Aye.
Barnetsky, aye. Member Tesfa.
Aye.
Tesfa, aye. Member Kanata.
Aye.
Kanata, aye. Member Fisher.
Aye.
Fisher, aye. Chair Wolf.
Aye.
Go the other way.
Wolf, aye. The motion passes.
Call next item.
Next on the agenda, item number 11, file number 16099, complaint filed by Michael Petrillos against the San Francisco Ethics Commission for allegedly violating Administrative Code, Section 67.7A and 67.15 by failing to post an agenda containing a meaningful description of each item of business to be transacted or discussed at the meeting and failing to provide an opportunity for members of the public to directly address a policy body on items of interest to the public.
Let's find jurisdiction first.
So moved.
Second.
Moved by Vice Chair Hyland, second by Member Kanata. Any public comment on jurisdiction? Seeing none, can we take this by acclamation? Seeing no objections, item is approved by acclamation. Member Kanata.
Public comment on jurisdiction, or is that?
I
oh,
did.
You did that, I'm sorry.
Yeah, just
Okay, so.
present the case.
At the next Ethics Commission meeting, which was October 18, 2016, I believe it was the chair of the commission, before the meeting started, made a statement about a new item of decorum that was going to be on the Ethics Commission's template. And Mr. Petrillos objected, saying it should have been on the agenda because they were going to take action and there should have been public comment.
Okay, great. Okay, Mr. Petrillos, 5 minutes.
Yes, as you heard from Jessica Bloom, we're still waiting for the city attorney to produce the draft document regarding the larger First Amendment issues of signage and what you can say at public comment. We are going on, 5 months, 6 months now, and this matter, I'm still pursuing it because even with dozens of attorneys at the city attorney's office and at the direction of Quentin Kopp and the Ethics Commission to produce this document about decorum and meeting rules, and also to help out the sheriff, whose deputies have to enforce it, we still don't have that document, okay? So at the meeting in question, Paul Rene reads out what he says are the new meeting decorum rules. This is not a scheduled item on their agenda. They do not have it agendized. They do not not take public comment on that. To give public comment on that, you had to use your general public comment to discuss what are their new rules. I have a real problem with that. I don't think they should have put such a contentious item that they should have omitted, that they should not have omitted such a contentious item from the agenda, and that's what they did. That's the basis of my complaint.
Thank you. Are any persons or witnesses to provide any additional facts or evidence on behalf of the complainant? Seeing none, respondent, you have 5 minutes.
Hi, Jessica again. So once again, I provided a fairly comprehensive written response with a lot of attachments. But the main point that I want to make is that from my perspective, I'm not a California licensed attorney, but I am a Missouri licensed attorney. And from my perspective, you have authority to order us to put something on an agenda and order public comment only if we engaged in policy making or regulation making. You don't have authority to order us to require public comment on notifications of existing policy, and that's what this is. So after Mr. Petralis demanded that we produce something in writing at the September meeting saying that he can't hold a sign with political messaging on it, we paid attention to all of the public records requests that he submitted to the various agencies, including the Sheriff's Office, City Attorney's Office, and the City Hall, I think, or maybe it was the Sheriff's Office that submitted the City Hall rules. With that information, we provided it to the chair, and the chair directed us to compile a paragraph that summarized all of those policies and put it on our standardized agenda template. So this isn't this meeting decorum paragraph that now appears on the agenda template is not something that we developed from scratch. It's a summary of several existing policies that already applied to Mr. Petralis' activity, and we were merely putting them on our agenda so that the next time somebody wanted something in writing, we had it readily available to us. What Chair Rennie did at the beginning of the meeting was merely read aloud this notification to alert the public that it was now on the standardized agenda, and then did not transact any business. He didn't ask his fellow commissioners for comment. They didn't debate the merits of the policy. They didn't discuss it any further. He literally just read it aloud and moved on. Mr. Petralis raised his hand and asked if he could make public comment on the policy, and he said he was free to do so during general public comment. So the Commission does provide 2 periods of general public comment, which is required by the Sunshine Ordinance. So to the extent that this is really just an argument about whether we should have engaged in some rulemaking or notice and comment process, that's just, I think, outside the scope of this task force's authority. And I'll take questions if you have any.
Okay. After I ask for any witnesses or persons that can provide any additional facts or evidence on behalf of the respondent. Seeing none, members? Vice Chair Hyland.
I seem to remember attending Board of Supervisors meetings where Angela Cavillo will state at certain parts, perhaps Victor, you can help me out here, about the board's policies on signage, support for candidates, support for issues, voicing. There's kind of like a general blanket, I think, policy that the BOS follows.
But I don't know that that's really the issue here.
No,
the
but
issue is the context of what is allowed and what isn't allowed.
Right.
It's really more about did the chair appropriately did the chair add something to the agenda that was pertinent and parcel to a procedure?
Yeah, to answer that question, I don't believe so. I don't think it was substantive, so I would find no violation at this point. But I'm just thinking out loud, just to kind of tie it into how the rest of the city bodies do their business. How does the Board of Supervisors, which I'm sure...
Just from experience, statements of policy bodies are made as necessary, but they're not made on a regular basis.
You mean what's the sign policy within the Board of Supervisor chambers?
I don't have that before me, but it's...
It's in the record, the policy.
I don't have my own version of it right here, but I believe it's in the packet.
That's okay. It exists. Yes,
Through the
Member
chair,
Canada.
there's a Board of Supervisors policy on signs, and there seems to be a City Hall building has a policy on signs. However, when Mr. Petralis asked the Ethics Commission for their policy, they said they didn't have one.
Didn't have one handy written.
They didn't know it. They did, and the one of the commissioners asked that one be written.
Yeah.
Okay.
Okay. That's just an aside.
No problem.
So to answer your other question, no, I don't think this was a substantive introduction. I don't think it needed to be agendized, and I think it didn't require any discussion, voting, or public comment. I don't think at this stage.
Mm-hmm. Okay. Anybody else?
Well,
Member Canada.
I felt, and the members of the committee felt, that because the Ethics Commission could not produce a policy, that this was a new policy they were coming up with, that they were just putting in their documentation at the end of their agenda. And since the policy on signs for the Ethics Commission was new, it was substantive, and it should have been agendized and allowed for public comment.
Okay.
Citations. The citations to the various policies that we pulled together are in the actual meeting decorum paragraph. So, our bylaws do have to go through notice and comment, and they do have to be public comment does have to be taken on them. And the first sentence of the meeting decorum paragraph is just word for word from our bylaws, which are cited in the meeting decorum policy. So, everything that all the notice and comment and all the publicly available opportunities folks had happened when those policies were put into place. And then this is just us telling the public these exist, and we're going to put it on our standardized agenda every week, every month, so that this doesn't happen again. And we don't, we didn't like that we didn't have anything to show him. And we didn't like that we didn't know if the chair could do this. And so we were happy that Mr. Petralis found all this information, and we asked for further clarification, and I continue to follow up with the city attorney's office regularly to try and get the memo that they promised Judge Kopp. And I'll continue to do that. And as soon as I have it, Mr. Petralis will be the first person who gets it.
So let me ask you this. So every deliberative body has the ability to determine how it wants to run its meeting and what it can exist or not exist. If they don't want people to turn off their cell phones, they can say, don't turn off your cell phones. We want to hear everybody's, we want to hear the variety of ringing because I want to know what it sounds like. There probably have been rules thereafter, but there's, as far as a disruption, it's really, I think the decorum part is really more about disruption of if I read the Sunshine Ordinance correctly, it's really more about, that's what it's really mostly about. And there are some parts that are specific, but, so the question is when there's a floor, let's say there's just a floor, like there's a minimum restriction. Anything above that restriction is at the discretion of the body. So the building may have restrictions, but that's outside of the hearing room. Let's say the body said they wanted to have, signs or people wearing, certain promotional items for the hearing, where they just allow it. It's not disallowed in the hearing itself. Maybe getting through the building it may be, but when they get in the hearing room, they could, put those things on. So so my question really is about, what the existing policy is for the Ethics Commission beyond the basic floor of restrictions. And so my question is about signage. Is there a global, for every board and commission, is there a global policy prohibiting signage, in that way? And I'm not asking necessarily in context, because if there isn't and the body has to make a decision about it, then it needs to have a deliberation on it and actually pass, approve of a policy, a new policy. So unless this already existed somewhere and they've already agreed to this sometime in the past.
So we don't view what we wrote to be us inventing anything new. We compiled the rules that exist from City Hall, the Board of Supervisors, the Sheriff's Office, and our own bylaws, and just put them in one paragraph so that the public was notified about them. We didn't add anything to that or go above the floor, so to speak. There was a question at the Compliance Committee whether or not we thought the Board of Supervisors rules applied to our commission meetings because we're Ethics Commission, not the Board of Supervisors. But we take the view that we are, we are a branch of the Board of Supervisors, and so the Board of Supervisors rules do apply to us in terms of what should and shouldn't be allowed in meeting rooms. And that might be something that you all disagree with. You might not think that we should comply with the Board of Supervisors rules, but our commissioners feel pretty strongly about that.
Yeah, I would say that's a choice, but I think because of the makeup of the Ethics Commission, who's appointed by who, you really don't have any specific requirement to do as or adopt anything specific to the Board of Supervisors, per se. Unless you just like the way they run their meetings and you decide to do it that way. I don't think there's necessarily any requirement of that.
So you would say that we would need to notice and provide public comment if we decided to follow the Board of Supervisors rules?
No, I'm saying that if you were to create, I would say that I hold the Ethics Commission and this body to be somewhat different than any other board and commission because it is a watchdog. It oversees how government operates. And so I would see that it operates differently and that it would have a little more latitude to be able to, because it's basically adjudicating state law for the most part. And so, and it's been found by a city attorney here in public forum that the Sunshine Task Force really obeys more state law than it does to local rules. And in certain cases, there was a case around holdovers of vacancies that city rule is 60 days, and the Board of Supervisors or whatever has to fill the seat. But on this body, it follows state law because this was an initiative-created body like the Ethics Commission wasn't created by the executive branch. And that rule applies to those kinds of bodies. So
our commissioners didn't want to allow signs at all, so I can't see them deciding that they're going to do something more than City Hall allows. Like, they're not going to allow people to bring in signs that are not allowed in City Hall into the hearing room and hold them up.
That's all fine. So if they want to disallow it and it's based upon some existing opinion or rule that can prohibit it, fine. Then it's an existing rule. But if you adopt that, I guess my point is if you adopt it as part of your procedures, your meeting procedures, or as a rule for your hearing, your how you run your meetings, and it didn't exist before, then it seems somewhat.
So I would argue it did exist before. I think that's where the breakdown is happening.
Yeah.
Okay.
Because we just didn't know about it. Okay. So when our commissioners made their decision, they didn't know if they had a rule to back them up, and so they asked the city attorney to produce a memo about whether they could do. And once that memo comes out, that I think could form the basis of a new policy that we might consider, and then that would be open to public comment. But for now, what we're doing is just and we can take this meeting decorum paragraph off. We're not married to having it on here. It's just that when Mr. Petrellis or someone else will ask us whether or not you can do something, we can point to, at least a summary of what exists. What existed when Mr. Petrellis asked and what exists today as of right now. We don't have anything separate from this. We haven't drafted anything new. No one debated anything. The commission hasn't met to talk about it.
Okay.
That kind of thing.
Got it. Okay, Member Canada.
So you just mentioned it didn't exist before, and now it exists.
The summary exists, right.
The decorum paragraph, what is cited here, existed in other bodies and in City Hall, but I don't see that it existed with the Ethics Commission.
I think she said it existed in their bylaws. Is that not what I
Well,
heard?
the first paragraph is from our bylaws. The Ethics Commission encourages and promotes integrity, blah, 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 treating all staff, members of the public, and colleagues with courtesy, respect, objectivity, and fairness. That's from our bylaws.
Right.
The second part is, you can see it's from the Board of Supervisors and the Sheriff's Office. It's all cited throughout, and then at the end, it cites all the different policies that we are summarizing and say, our meeting decorum paragraph isn't meant to displace those. This is just a summary.
Right, but other than the first paragraph that's in your bylaws, it seems to me that the commission is adopting these as new for the commission. And to me, if that's the case, it should have been agendized and had public comment because it's something new for the Ethics Commission. That's
If you all tell us that we are not entitled to follow City Hall rules, Sheriff's Office rules, and Board of Supervisors rules without adopting them ourselves, we'll adopt them ourselves. That strikes me as not true. I mean, we should be able to follow in the building where we are meeting, subject to a governing authority. We should be able to follow those rules without having to go through our own process. And I mean, those are public policy decisions that were made by people over our heads. Why should we have to make up something else? And the provision that we are here under, that I can't remember his name, but the third compliant, the gentleman who wasn't.
Member Moss.
Yeah, he said, he pointed to 6715C, where it says a policy body may adopt reasonable regulations to ensure that everything is carried out. It doesn't say we have to. It says we may. And we don't want to do something different than what's already allowed. We want to follow what's already allowed right now.
Okay.
Until the city attorney's office says otherwise.
Vice Chair Holmes.
Through the chair, let's assume, for argument's sake, that is the case, that they should have agendized this. And then it goes to the question of what's the watermark as far as a substantial policy issue or not, or action on an item. I still think this is an administrative thing that falls below that threshold.
Well, but you have to determine, you're asking two separate questions,
Yeah.
okay? So one question is if you weren't operating in a certain mode, and then you decide sometime later that you are, and it's now some new procedure that is that the public or anybody participating would have to provide. The question then becomes whether it is a policy that has to be created and adopted by the body, okay, or if it's just a regular practice that exists. So it's not a chicken or the egg kind of thing, so to speak. It really is kind of like if you're going to have a meeting in a certain building, the city requires that certain things have to happen.
Actually,
if it's in a private
let me
building.
interrupt. That's not quite what I'm saying.
Okay.
What I'm saying is, if this new thing is in fact a new thing, and I don't believe it is, I think it's something that they're claiming quite accurately was always a thing, and they just chose to notice it more clearly. That's how I see this. If it is a new thing, does that thing fall above or below the threshold of an actual item, substantive, or is it just something administrative that doesn't need a vote, public comment, et cetera, as we have in our own commission? You know, there's some things that we don't have to, because it's
Like
not
I said, if you're departing from a regular practice that people have an expectation of, that's been precedent, if there is by their own testimony, they didn't know that certain things existed. Okay, that is concerning to me. So all of a sudden, these things exist, but we didn't know that they exist. So then we get to implement them.
I think
that what you're saying?
No,
I think we'd rather ban it. We'd ban signs if it were up to us.
But you see, that's the point. You haven't made a decision about it.
Right, we haven't. We haven't made any decisions.
And I think that's the point here is that
I agree.
So that the question then becomes, if you do make a decision to operate in a different way, and it's going to be a decision that this is how we're going to operate in the future. You know,
I think that
it's a matter of adopting a new procedure. So the question is it policy? I don't know. Is it because it already exists, because the building already has a rule on it? You know, I don't know. It's a little.
Like,
it's
imagine, Chair, imagine if the Ethics Commission started meeting at the Symphony, and the Symphony building didn't allow cell phones. Mm-hmm. Would we be making new policy if we put something in our agenda that said no cell phones pursuant to the building policy?
If you didn't notify the public.
We did notify the public when we put it in there.
If you did notify the public that you put it, and either you said it at the beginning of a meeting, or whether it's in your agendas.
But that's exactly what we did. We read it out loud at the beginning of the very first meeting.
It was already on the agenda, and it was then read out aloud at the meeting. Is that
right.
correct?
It was not agendized.
It was put on the actual agenda, right? So in the notifications.
Yeah,
several of these notifications. We have materials are available at 25 Van Ness, disability access, language access.
This is what's at the end of the agenda.
Standard language.
The post-stamp.
Notifications.
That kind of stuff. So that's the thing.
So I think it's fundamentally wrong and a misinterpretation of our obligations under the ordinance to argue that if we move to a new building, we would have to notify the public and give an opportunity for public comment on every one of the new building's rules in order to be able to follow them.
I understand that, but you haven't been at that building for 10 years. If you brand new are at a new location.
I think that just speaks to something that you said earlier, which was this is a longstanding policy. I'm troubled they weren't aware of it. It's never come up before. Okay. We had no reason to be aware of it. Mr. Petrellis was the first person on Leanne and my watch and all the commissioners' watch who ever tried to bring in a political sign.
Okay.
We would absolutely prohibit them if it were up to us, if we were going through a notice and comment rulemaking process, because electioneering communication in front of the body that is responsible for enforcing electioneering laws in the city is completely inappropriate. But we don't want to do that until we have a memo from the city attorney's office, at which point we will engage in policy making. Right now, we're just notifying the public of what exists.
Got it. Member Canada.
I don't know what I was going to say. But it wasn't only the commissioners. You had a city attorney there, and also a member of the sheriff's department, and nobody seemed to know the rules and regulations for signage. So the fact that rules did exist that you want to now adopt.
No, not adopt. Just inform the public that exist.
Just notice.
I mean, the sheriff was prepared to eject Mr. Petrellis based on this rule. The rule applied in the meeting room. This isn't something that we just made up. But he put the sign away, and so the sheriff's office stood down. The rule existed when this happened.
So let me just say, if the body didn't know, and there's a rule inside every single room in the building, and the sheriff is there to enforce the rules and the law, then the sheriff, without any apprehension or order or direction from the body itself, could automatically act and deal with the situation on the spot. Period. The fact that I would contend the fact that they put it in there, it wasn't in there. In their agenda, communication to the public on the rules and the procedures could possibly be kind of a moot point, I would think.
And through the chair, I mean, the members of the committee objected on the microphone, saying we don't think this is right because it violates a rule. We can't produce it in writing right now.
Okay.
So.
Member testify, and then we're going to have to move on.
I just want to make the response to Member Kanata that the expectation that the sheriff or the commission members or the council that's present will know all rules is completely unfair, and that is not the person's role. The person's role is, when requested by the chair or one of the members, to write a memo or look something up to do that. But to know it off the top of their head, is not their role. And if they do look it up and produce a memo, it's not them creating a law. It is them looking it up and writing it down and printing it out for people to now know what it is. But it's not them creating something out of cloth. So even if it was a memo that's produced, it still would not rise to the level of them creating something new. It's them going to the very vast library of rules and looking it up and producing it, because commissioners don't have time to do something like that.
And I understand that when it comes to all the rules that might apply, but I would think that the chair of the commission should know how the commission operates.
They don't. There are so many rules. I go to commission meetings on almost every single day for my job, and there are so many rules that the general counsel that is there to advise is able to look them up and report back. They don't know all of them. There are hundreds of them. So that's just a practical, as a government employee, thing for everyone to know here.
Okay, I'm going to stop this discussion right now. Let's move to rebuttal. Everybody can have their last say on this matter, and then we'll decide what to do thereafter. So, respondent, you go first. 3 minutes for rebuttal.
No rebuttal.
Okay. Complainant, petitioner.
Hi, Michael Petrellis again. I'd like to address your point about all the rules. This is a very big rule. It has to do with the First Amendment and what you're allowed to say via signage. This should be paramount at the concerns for this Ethics Commission in particular, okay? And with an ex-judge and these two downtown lawyers all going after me for trying to hold a sign. To me, that is visual messaging. They should know what their rules are. It should not be taking 5 months now for the city attorney to produce a memo about free speech signage issues here in City Hall. After all this went down, Ray Hartz and I, another Sunshine Advocate, and I had a meeting with Sheriff Hennessy and Eileen Hurst. They promised that a work group had been formed to look at all this matter of uniform rules for signage in all of these meeting rooms, because the sheriff wants her deputies to have a set understanding of how to operate when the public shows up with a sign. Regardless of what my sign said, I deserve the right to hold up a sign that is not larger than 11 by 17. And I am saying, pertinent to this complaint before you, that there was a violation, that a major consideration of conduct at their meetings was put on the agenda without proper notification. Thank you.
Okay, members.
Motion to find no violation of 67 and 67.15.
Vice Chair Hyland.
Second.
Second by Member Hensy. Discussion?
What was the motion again?
To find no violation.
Yeah, sure.
Okay, public comment?
Am I still here? Okay, David Pilpel. Several things, although it seems like this is fine. If you have time on your hands and feel like it, please read the general orders of the state PUC. They're lots of fun and rather thick. So, yes, I understand. Lots of them. I have some issue with the content of this paragraph, but that's really, I think, not before you. The question is whether 67.15C allows a body to regulate the conduct of its meetings without a separate rulemaking process. And I think the answer is yes. It says may adopt, but it doesn't say how, and it doesn't require it. And certainly in the conduct of meetings, the chair has discretion for how meetings are run generally, subject to laws and the rules of order or the bylaws of the body, subject to the appeal to a decision of the chair by a member. et cetera. There are various items that are listed in the boilerplate on the agenda, the Ethics Commission agendas, your agendas, anybody's agendas. Some of these are required by law, such as the electronic device prohibition. So you're actually supposed to state at every meeting that the ringing or use of sound-producing electronic devices is prohibited, and anyone who does so may be removed from the room or asked to leave. That's a requirement of Chapter 67A of the Administrative Code, a separate law that was passed by Michael Yockey on the Board of Supervisors. Okay, there is a larger context to what's happening at the Ethics Commission. It wasn't just, in my opinion, okay, it wasn't just Mr. Petrellis and his sign and his signage and his candidacy and whatnot, which people can support or not support. It has to do with Ray Hart's attending meetings of the Ethics Commission and using expletives and however he chooses to conduct himself at those meetings, as you've seen here. It has to do with the comment that one of the residential builders made a number of years ago at the Building Inspection Commission, saying that Amy Lee, when she was the acting director of DBI, who was then pregnant, had pregnancy brain and was unable to conduct her affairs properly. There are major issues with how the city can constrain public comment and conduct during meetings, and those have to be narrowly tailored to serve whatever appropriate government interest exists, which is why I suspect that it's taking this time for the city attorney to properly draft and review a policy statement, because it's really not just about Mr. Petrellis. I agree that there's no... and there are major issues here, and this needs to be properly reviewed. I encourage you to vote for the motion that there is no violation here. Unless you have questions, thank you.
So one thing I have to say is, it's interesting that in 6715C, it uses a very specific term. It doesn't say just procedures or rules or anything like that. It uses the word regulations, and it uses it 3 times in that whole section for pretty much the same purpose. So it's an interesting word to use, specifically regulations, because regulations generally are policy. They're not just rules. So, lacking there a definition in the ordinance of regulations, it makes it a little difficult without having legal counsel to kind of answer that kind of question. But I'll ask member of the public, Pilpel, if he has a comment on that.
It was pulled straight out of the Brown Act, 54954.3C. It's the B. It's the same language from that whole section that was imported into 67.15. That's where it came from. The word regulations came out of state law, and that was the term of art at the time.
My question is what is the difference between, does a regulation require an approval? Is it a deliberative object versus creating rules like in bylaws, that kind of thing?
And my answer is it may. There's no definition in the Brown Act or in the Sunshine Ordinance for regulation as is used here. So I believe it was merely a term of art that you can enact regulations, rules, procedures. It was meant as a catch-all term for how meeting conduct is regulated.
Okay.
It wasn't specific to a regulatory process or scheme.
Okay. We usually don't take public comment from parties during a motion. Okay. It would be public comment if you answer the question. But I mean, if nobody objects, I will allow Ms. Blom to answer the question.
Let's hear what she has to say.
Okay. Are you okay with that? Okay.
I asked Andrew Shen this question, who's the city attorney, so I just thought you'd like to know. The regulations, the state has an Administrative Procedure Act which governs the way state agencies have to enact regulations. The city, in my opinion, alarmingly does not have a similar act, so we don't have any, there's no guidance for any at all for how we should adopt regulations.
Okay, very good. The other point I want to make, that under parliamentary procedure, there's a lot of latitude with regard, outside of all this, about how meetings get run in general. So it really doesn't even have to so much be codified, because we already, as a city, adopt by default Robert's Rules of Order anyway. So anything that's in the big, thick gold book, is applicable in the way you want to run your meetings. Like, most people don't really run their meetings that definitively according to Robert's rules anyway, because But you watch the Board of Supervisors; they have their own set of rules. Congress has their own set of rules, that kind of thing. So, okay. Anything else for the good of the cause? Roll call.
On the motion, Vice Chair Hyland.
Aye.
Hyland, aye. Member Barnetsky.
Aye.
Barnetsky, aye. Member Tesfa. Aye. Tesfa, aye. Member Kanata.
No.
Kanata, no. Member Fisher.
Aye.
Fisher, aye. Member Hinsey.
Aye.
Hinsey, aye. Chair Wolf.
Aye.
Wolf, aye. The motion passes.
Okay. The next item, people don't leave. It's not time yet. The next item, which I know some people are interested in, the reason why this was put on the agenda was not specifically for the purpose of discussing the matter that's before ethics, per se, but it was dealing with a lawsuit of which the task force is party to, and it has been named in. And so by that virtue, there was some concern of mine, and also speaking to legal counsel, that there might have been some concern on his level that we should have some discussion about it. Since then, before this agenda was created, and having spoken to, just for 30 seconds, spoken to Ms. Blom and DC Acola, it was found that the items that are contained in the lawsuit are different than what is coming before the Ethics Commission. So they're really, the concern I was having was if there was going to be conflicting issues, like duplicative issues. So if the Ethics Commission had made a decision and then the courts made a completely different decision, we'd have a problem. So we wanted to make sure that if we had to deal with this in court, we were going to determine whether we should postpone and request a postponement of the Ethics Commission's hearing until the lawsuit was finished, and then decide whether we needed to mount a defense or not. And by having a closed session, it would provide us an opportunity to deal with those issues that were cited in the lawsuit, which had nothing to do with the violations per se that are before the Ethics Commission. So there's no need for us to have it. We're moving forward with the Ethics Commission's hearing on February 27th, right? And I will be attending, and I've asked any task force members that were party to the Joel Warren case last year to attend. You don't have to, but it would be good, because if there's any information you can lend in your recollection. But I've also asked our two member attorneys, Member Baranetsky and Member Tesfaye, to also attend with DC Acola, just in case there's some procedural or some things that may pop up that they might be able to lend a hand with. So I just wanted to announce that. Yeah, Member Tesfaye.
Use the mic.
My question just had to do with the number of us attending and noticing of the meeting publicly.
I don't think, well, I would
The
say.
meeting should be noticed because it's a.
No, but the noticing of our attendance at the meeting.
Right. So I'm announcing it here, and I've announced it before, but I would think that it only matters if there's a quorum.
Right.
Okay?
right.
So it would mean 6 members would have to be attending. So if there's anybody has comment about that, I'm happy to take comment.
What's the date on it?
February 27th. And is that 1:30? No, 5:30.
Sadly, it's at 5:30, but we'll put you first.
Okay.
Right after the minutes.
Okay,
And
great.
public comment.
And is there anything?
Right after the new decorum announcements.
Ms. Blum, is there anything else you wanted to add? Did I cover it all?
Right after, no more meeting decorum announcements, but yes, no, nothing to add. I don't. That's a good question about the Brown Act. But I don't know if you'd be transacting business. I think you'll just be responding to us. So
Right.
I think you're probably okay, but you could
All of
ask.
us would just be sitting in the back of the room.
Right.
You'll be observers.
Can we wear T-shirts with words
I was
on
going to
them?
wear a
You
T-shirt.
can.
Okay.
And an 11 by 17 sign.
Sure.
Can I bring
Okay.
a sign, dump Trump or
Is there
something like that?
anything else on this subject?
Public comment?
Public comment, go ahead.
David Pilpel. I appreciate the statement you just made. I'm sorry I had to wait 5 hours and 40 minutes to hear it. If you knew this information by Friday afternoon, the item either should have been pulled from the agenda for tonight or some of the explanatory information that you just gave should have been on the agenda. Because otherwise, you created the expectation by listing it on the agenda that there might be this closed session tonight, which now isn't happening. And I'm pleased that it isn't happening. Furthermore, as I understand it, the request to reconsider from Mr. Warney, which I looked at briefly, and I still haven't seen the Ethics Commission response, was more to the handling by DPH and perhaps by this task force, but the commission has already done all it can under the law and under their procedures, which is to issue a warning letter to this task force about the 45-day rule. There's nothing more or else, in my view, that they could do. So I don't think the task force needs to be worried or that concerned with the rehearing request.
I understand.
Or reconsideration request, however it was packaged.
Some of it is because it is a rehearing, and Mr. Warney had provided additional information that was not provided originally. There was just some concern because none of us were at this hearing.
I'm going to have to go back and look at my notes if I was on the task force at the time and if I had anything on this. But
You
okay.
did. I remember it.
Okay, well, then I'll go back and find those because I keep everything.
And it's also...
You making public records requests? You want me to go look?
It might have been one of your many absences.
It's also part of somewhat also just exercise for us because it's unusual that the task force be called before the Ethics Commission. So that's, we want to take it seriously. We want to make sure.
I understand, and my comment from earlier is still noted about whether or not this body can hold a closed session under those circumstances, but we'll leave that for another day.
Litigation?
Yes, as to whether or not it is actual pending litigation against this body.
Well, but that was the purpose of having a conference with the city attorney to determine that.
I understand, and my position is that that's not correct. But anyway, we'll handle that another day, perhaps in another venue.
Okay.
The woman next to me went to law school.
All right, very good.
I think we're good.
Okay.
Thank you. Good evening.
Okay, thank you.
Good night and good luck.
Did you have something to say, Mr. Petrellis, about this issue?
Thank you very much for putting in all this time. I'm sure many of you left work just starting at 2 or 3 o'clock to get here for a 4 o'clock meeting, and it's now almost 10 o'clock. And I got to say again, even though you voted against me twice, thank you for serving democracy. Thank you.
Thank you.
Thank you. Okay, administrator's report. Let's get through some of this.
Regarding this item, is this continued the call or tabled?
The administrator's report?
I mean, item number 12.
Oh, 12? No, it's tabled.
Okay, can we, on that motion, can we take that up without objection to table the matter?
Yeah, we can table it indefinitely. Well, it'll just die at the end of the meeting anyway.
I think you can get any.
So without objection, folks, number 12 is tabled. Thank you.
Item 13, administrator's report, complaints and communications. There's not much out of the ordinary in my report this week. The number of pending complaints we have is down to 24. About half of those are scheduled for committee. The other half are scheduled to appear at the next task force meeting. So awesome. And there are a few old items in EOTC that I'm dealing with. I am writing letters to those complainants to try to turn them into hearings instead of complaints.
Great. Thank you. Doing a good job. Any announcements, Commodore 14?
Thanks for these. Very good.
Microphone, please.
I have one brief, something for you to consider. As you saw today, I think it was item number 5. It took a really long time to get through. That was the item that had to do with the Department of Public Health. I feel like part of that, it came out of the Complaints Committee, was because both the respondent and the complainant was present at our meeting, but the respondent was not. And so it made it very difficult to ascertain certain facts to help prepare or perhaps not allow that complaint to come here yet. So just I want you to think about the potential for requiring parties to appear at complaint committee hearings to avoid that. You know, we don't want to be the ones that say, no, you can't come before the task force. And we are very concerned about doing that and not giving them their time before all of us. But it took a long time today. So,
Vice Chair Highland.
Through the chair, I think we tackled this problem in policies and whatnot a few months back, and I think we determined that it did not need to be there, but perhaps we could add a line along the lines of, participation attendance is strongly required and will help encourage, sorry, thank you for the correction, strongly encourage and will help your case to potentially appear before the full task force.
I believe we already have that.
We do have
communications.
that. Yeah, we do have that communication. And in that case, if the respondent doesn't show up, it does hurt the complainant. And so the respondent might not show up.
Yeah, so what I was planning, what I had thought about almost just about 30 minutes into number 5 was that I was going to refer it back to complaint committee and say, not enough information.
Go for.
We'll send, I'll request Victor to send a memo strongly urging them or demanding them to, or requesting them to show up at the complaint committee, but or the complaint committee just continues it and does the same thing.
Requires them to show up?
No, not requires. Strongly urges, demands. We can't require them. We don't have subpoena power.
But require them as much as they are required to appear here.
Appear here. Oh, I see what you're saying. Yes.
Because
I believe we did that at the last meeting.
I think
where
we have a couple.
Continued an item.
We did for one.
And required that the.
Oh, okay.
Yeah,
that's right.
we
can.
Representative.
We can require
do
that. So, yeah, we could do that.
But we could do it from the outset.
Yeah.
Or
Right.
not. Anyway, something for you to consider. I know we can't.
Does that affect the 45-day rule?
No, because
It's already in committee.
No, because the only purpose for the 45-day rule is determine whether information is public, period. Not even whether it's within our jurisdiction or not, just whether it's public.
So a committee can do that?
Well, we have authorized the complaint committee to make that determination. I think what member of the public Warfield was bringing out early on was just the procedure in reporting. And so we should take a look at that because, I don't know, every time I read it, it somehow rings differently. But I know that in previous iterations of this task force, he knows very well. The first day that I've been on this task force, he was actually a complainant. And he knows very well that it never has happened that way in all those years. So for him to point it out now to say we've been doing it wrong is a little disingenuous. But
that's a good word.
I would just say that we can look at it and see if there needs to be a different way to
Would you like
comply.
the committee to make that statement at the committee level?
The problem is if the petitioner isn't there, then they have to be notified directly.
They are notified when I send them copies of the minutes.
But is it within the 2 days of the next meeting or within 45 days?
Yeah.
So that's really was his point. And really, all it has to do with is whether to determine whether the item is public or not. Nothing to do with jurisdiction or procedures or anything like that. And so I know he tries to extend that, but really it's just all about whether the information is public. So it doesn't apply to open meetings or anything else with regards to operations of the ordinance or the Brown Act or other areas of the CPRA. Just 6721 or 6725. That's all it really applies. Okay, that's it for the good of the cause. Move to adjourn.
Move to adjourn.
Second by Hensy, by rising vote.